We're going to go ahead and get started on the agenda for today. Child Custody and Domestic Relations Task Force. My co-chair is Representative Heather Scott, who's going to be taking over the latter part of your today. We can start out reading a statement that we have just so that everyone keeps in mind the focus of the task force. And so, and hopefully everybody hear me okay. We don't have microphones, but I want to make sure everyone can hear. Okay, so back there. Okay, we'll try to speak up as loud as we possibly can. So this task force has been convened because our constituents have shared a lot of concerns with us about outcomes in child custody cases. Our focus here is to study how child custody and family laws are being interpreted and applied by Idaho courts. We're trying to decide, one, whether Idaho courts in general are applying the law in a way that's consistent with legislative intent, and two, whether we as a task force should recommend changes to the law that would provide courts and citizens with more clarity. We also want to explore whether there are policies the legislature could enact to ensure that everyone involved in child custody cases has fair access to court process and adequate legal representation. However, we want to make it clear that the legislator's role here is limited. The Idaho Constitution separates government powers into different branches. The legislature makes law, but the courts decide cases, and we are not here to second guess the decisions of individual judges or to undermine the integrity of the courts. While the co-chairs welcome public feedback and encourage robust discussion, our purpose here is to consider the law, how it's being applied, and whether it should change. We ask that everyone presenting or testifying to the task force today keep that purpose in mind. Please be aware that the co-chairs will likely rule as out of order any commentary that is beyond the scope of the task force purpose. And that is just to help us to keep our focus as narrowed as we possibly can, but also to be able to get the information that we're needing to help the legislature moving forward. So we appreciate you to keep that into consideration today. We have a full agenda. We will be taking a lunch break approximately noon. We'll try to stay as close to the time schedule that we have. So we appreciate it. We do have two other legislators that serve on the task force that are on their way. They got stuck in traffic, but we are going to go ahead and get started because we want to be mindful of everyone's time and stay as close as possible to the agenda. So are we doing? Okay, not today. Okay. Yes. So we are going to approve minutes later on. We want to make sure everybody gets to see those. For our committee, you have your table cards here. So if you have a question, since we don't have microphones and we don't have lights to look at, if you want to just turn your table card over to the side, then we will know you have a question, and we will utilize that as our way to know that you do have a question. So we are going to go ahead and start with so actually put us a little bit ahead, so that would be good. Just one more time. We have Jeff Brody, and if I slaughter anybody's names, please correct me. So I'm notorious for doing that in my committee, it seems like. But just let me know. And when you present today, or when you testify later on today, make sure that you state your name for the record, because we want to make sure we get everything correct that way for our secretary, and that will be most helpful in the minutes. So we will start with the overview of the Idaho Judicial Council. So Jeff, if you could go ahead and, like I said, state your name for the record, and then you can go ahead and proceed.
Thank you, Mr. Co-Chair. Appreciate the invitation and the opportunity to come before this task force, and I always appreciate the opportunity to educate people about what the Judicial Council does. Oftentimes that also involves explaining what the Judicial Council does not do. So I am the Executive Director of the Council now. I've been doing this since the day after I retired. After more than 20 years as a district judge in Lewiston, I had been serving on the Judicial Council as a district judge member since 2018. And I took the executive director position on an interim basis that turned into a non-interim basis a few months later, and I've been doing it since. So I think I'm, of the people involved with judicial council, I'm kind of the senior person in years at this point in time due to some turnover we recently had. It did work. There we go. Judicial Council is approaching being 60 years old. It was created by statute back in 1967. So it's existed since that time. Into chapter in legislation, it's Title I, Chapter 21 governs the operation of the Judicial Council. At this point in time, after some legislative changes made back in 2023, the Judicial Council consists of 9 members. The one that is automatically a member and the chair of the Judicial Council is the Chief Justice of the Idaho Supreme Court. There is also 1 district judge member, 1 magistrate judge, 2 practicing attorneys, and then 4 citizen members of the Judicial Council. All but the chief are now appointed by the governor since the legislative changes were made in 23. Before that, the 2 attorney members were appointed by the state bar, as was the district judge member. The magistrate judge was not a full-time member until the changes were made in 2023. The Judicial Council is not large. It's basically consists of 2 part-time people, myself, and my long-serving administrative assistant, who's, I think I'm the 4th executive director that she has worked for. Budget is $160,000, and I usually spend a total of about 2 minutes in front of JFAC talking about that, because I think it's probably about the smallest one that you all have to deal with. For those members on the Judicial Council, this is volunteer work. Most of the citizen members have jobs. Of course, the attorneys and the active judges do have jobs. So this is volunteer work that they do in addition to what they're usually doing. It's pretty much unpaid. The non-judicial members of the Judicial Council are paid $50 for every meeting that they attend. And meetings are the least of the work that the council does. As I'll get into some of the obligations that we have, and $50 does not go very long considering some of the hours that they have to put in reviewing applications and some of the other complaints that come before the council. We're currently down 2 members. District Judge Nancy Bastion's term expired on June 30th, and as did Kathy Simpson's term as one of the citizen members. She served 2 6-year terms. After 12 years, she stepped off of the council on June 30th, so we're currently awaiting the governor appointment of 2 of those additional members of the council. Primary duties that the Judicial Council has, we spend most of our time in 2 areas. One of them is assisting the governor in filling vacancies, or, as has recently occurred, new positions at either the district court or appellate court level. We've recently worked on 2 district judge positions, 1 in the 1st district, 1 in the 7th district, that were authorized by the legislature this spring. So that's one of our obligations, is to assist the governor in filling those positions. The second thing that we do is recommend the removal, discipline, or retirement of state court judges, and that includes all levels of judges, magistrates, district judges, appellate court judges as well. I know the judicial selection process has come up, and I think there's been some information provided to the task force already. I do want to explain there are some common things that occur in the selection process for judges at all levels of the state, but there are some things that are unique to each position as well. When there is a judicial opening due to a vacancy or a new position is created, the first step is giving the notice the opportunity to apply for the position to all the bar members. You obviously have to be a lawyer before you become a judge. So that goes out to all the bar members, and that includes in-state and out-of-state people who are bar members. The applications are submitted, and at least in the case of the Judicial Council, this is a pretty extensive application. You don't decide the day that you're going to apply, fill it out, and send it in tomorrow. It takes a lot of work. It requires getting your law school transcripts, writing samples, and a lot of thought and a lot of questions. So it is an extensive application that ultimately comes into the council or the other body that's considering the applications. Once the application process concludes, then a bar survey is done. Because people are applying, our judges or existing lawyers, we survey people that know and work with them the best, and that's other lawyers. So that survey goes out to about 5,500 people. The response rate is not what we'd like it to be for surveys, but it does ask lawyers and judges to evaluate applicants on a number of categories. First of all is integrity and moral courage, their experience level, intelligence, wisdom, capacity to be fair-minded, their industriousness, their personal habits, as well as judicial temperament, and then also their writing ability. So that's done on a 1 to 5 scale. I don't think anybody feels like it is a perfect tool because somebody's idea of a 3, maybe somebody else's idea of a 4. But you do hope that you get sufficient responses, and hopefully it's being done by the same people so that you can at least evaluate some trends among your candidates. As part of that process, we also do take public comment, as do magistrate commissions, and we oftentimes receive public comment on some of our applicants. Following the bar survey, then interviews are usually scheduled, and this is one of the differences. Judicial conference, or the Judicial Council we interview everybody that applies. We usually have a limited number, probably the most we've ever dealt with is about 14 applicants. So that was about a day and a half, but for the most part, it's less than that. So the Judicial Council interviews all of our applicants. Magistrate commission, which I'll talk about here in a second, usually narrow the field because they're getting more applicants. They oftentimes narrow the field and do not interview everybody, but each commission has their own rules for what they're going to do. Part of the emphasis here, of course, is on family law, domestic relations, child custody matters, which are universally heard by magistrate judges. So in the case of magistrate, there's only one path to becoming a magistrate judge, and that is through application to local magistrate commission. There are 7, each judicial district in the state has its own magistrate commission. They vary in size because each commission has to have at least one county commissioner from each county in the district. So my magistrate commission in the 2nd district was fairly small, so we only had 5 counties, but you get up to the 7th district with 10 or 11 counties, magistrate commissions can become fairly large.
Wait, did you say each county has a magistrate commission?
Each district has a magistrate. And the commission includes includes one county commissioner from each county, along with, I believe, 2 mayors from within the district, 2 attorneys, and a magistrate judge, and of course the administrative judge is the chair of those local district magistrate committees.
And don't let me interrupt you, but are you going to explain that? Yeah, you know what?
Oh, and let me just interrupt really quick. Sorry. So for those that just came in, if you have a question, because we don't have microphones, just bring your card to the side here if you have, and then and those that are online, we're watching to make sure if there's any questions that come up there. So just for those that got here a little bit later, but Representative Ehart.
Chairwoman, just so I don't interrupt you, are you going to go over the purpose of the Magistrate Commission in your presentation?
Yes.
Mr. Reed.
Thank you. I just, so I want to inform them and move it.
Go ahead.
For magistrates, the requirement experience-wise is to have been a licensed attorney for 5 years. That's the minimum to become eligible to apply for a magistrate position. So the Judicial Council plays no role in magistrate selection process. This is exclusively the province of the local district magistrate commissions that are formed. So that magistrate commission actually makes the selection of the new magistrate judge to fill either a vacant position, or I think there are also 2 magistrate positions created by the legislature this spring that they either have filled or are working on filling right now. Once a magistrate is appointed, they are serving an 18-month probation term. And as part of that process, before the conclusion of that 18-month probation term, the Human Resources Department of the Supreme Court does conduct a performance evaluation for that new magistrate, usually around the 1-year mark of their work. That is a targeted survey for people who are frequently in front of that magistrate, and it's not just lawyers, but it's other types of individuals that may be in contact with the court. You're trying to target individuals who are familiar with that judge, so you do get meaningful feedback. You don't want to be sending it to somebody who's never in front of that judge. So it is a targeted performance evaluation that is done by the Human Resources Department of the Supreme Court. The results of that performance evaluation are then provided to the Magistrate Commission, who is making their review at the end of that 18-month probation term to determine whether that judge stays on the job or not. There have been occasions when the Magistrate Commission said no, and the individual has not been allowed to continue to be a judge after that. It becomes a new vacancy to be filled. It's rare, but it has happened. If they are retained after that 18-month probation period, then the magistrates appear on the general election ballot, subsequent general election ballot. So they are appearing on the ballot in November. And the type of election, as you've heard, that magistrates face is a retention election. They show up on the ballot and say, should this person be retained as a magistrate judge? Madam Co-Chair.
Representative Behar.
Thank you, Madam Chair. Sir, out of curiosity, why do we vote that way? Why do we put them on the ballot and now should they be retained? It seems like it's almost like a double negative vote and impossible to remove someone that way. Do you have any knowledge as to that?
Madam Chair. The retention election for magistrates is because the legislature says so.
Okay, thank you. That's our fault. Thank you.
There have been a couple of occasions where magistrates have I know one of them occurred in the 2nd district, and I think there was also one in the 1st district.
You have a follow-up question?
Madam Chair.
Yes.
This is Senator Ruckty.
Senator Ruckty.
Madam Chair, Mr. Broody, are we having difficulties getting lawyers to apply for open judicial positions? And if we are, what are the, based on your history with this, what are the reasons?
Madam Chair, hello, Senator Ruckty. Well, certainly at the Judicial Council level, we are having difficulty getting applicants. Looking back since 2021, so as you can see here with district judge selection process, that's where the Judicial Council comes into play, as we do vacancies at the district court level or the appellate court level. As I set forth here, the obligation on the Judicial Council is to send a list to the governor of 3 to 4 people to fill those positions at the district court or appellate court level. Since 2021, we've had great difficulty at the district judge level. We average right now a little over 4.5 applicants going back through, hang on a second, I did bring this with me. So that's been 24 vacancies at the district court level that we've had to work on since the 1st of January of 2021. So we have had an average of a little over 4.5 applicants for those positions. The most we ever saw was a position in Ada County early in 2021 where we received 10. But as you can see, we have to send a list of 3 to 4. We've had a number of occasions over the course of the last couple of years where we've only had 3 applicants. So there wasn't a lot of mystery to the interview process. The reasons for it, the Supreme Court has dealt with this issue before, and they have surveyed the bar as to why they're not applying for judicial positions. You know, there's a lot of speculation. It was about pay, but I think pay came in about third as a concern among sitting attorneys on applying for district judge positions. I think the most recent survey from a few years ago is still out on the Supreme Court's website. So I think there's various reasons, and pay is certainly one of them. The legislature made a substantial adjustment in pay this session, and we've heard through the course of some of our interviews in the last couple of months that has made a difference. We've actually had some applicants tell us that that made a difference because we've been in a position where there are some elected county prosecutors, and even we found out some deputy prosecutors here in Kootenai County whose salary was in even more than what Chief Justice of the Supreme Court is. So we get a lot of applicants from governmental positions. We do not get as many applicants as we would like from the private bar. For district judges, you have to have at least 10 years experience. We are, I think, at both the magistrate level and the district judge level, we're skewing younger and less experienced in terms of our applicants. We have a lot of applicants for district judge positions that are in that 11, 12, 13-year experience range where we'd like to have them at 20 plus years. But that's rare that we get those kind of applicants for a district judge position. Historically, magistrate positions do get many more applicants. For that same time period, going back to 2021, magistrate applications were in the range of 16. And some positions, I know an Ada County position a couple of years ago got 27 applicants. I think a position in Canyon County got 24. So magistrate applications have always been more than the district judge positions. And, but I think recently, one of the new positions that was authorized this spring only got 4 applicants for a magistrate position, I think, in Twin Falls. So it is something that we are concerned with. But as I say, the reasons why kind of vary. Pay has been one of them, but it was not number one. I've always been concerned about relocation because both magistrate positions and district judge positions have residency requirements. For magistrate position, you have to reside in the county where you're going to be presiding and where you run. And if you're applying from outside of the county, you're going to have to relocate. And there are some areas in the state that are difficult to relocate to. We're going to be facing one of the designated district judge locations is in Blaine County, Sun Valley. And you're going to try to relocate to Sun Valley. It's going to be difficult given the housing market. So that's going to be something that comes in the next few years when Judge Williamson retires in Sun Valley. So we don't see a lot of applicants from outside of the districts where our positions are open, and that's part of the reason why is potential relocation for those people.
Been interrupted. Do you have a follow-up, or was that good?
No, I'm good. Thank you. Thank you.
Mr. Brady, could you, sorry to interrupt you, but I wanted to go back to the survey briefly. So you said pay was third. Do you know what first and second were?
I'm trying to think of what they were. One of them is just kind of I guess I will say that kind of the way that judges are treated and talked about. I think judges do not want to be politicians. That's why you become a judge. And I think some of the things that have been directed towards judges has caused people to not be as interested in doing that. Some of them are just not interested in the work. So I don't recall exactly what they were, because we expected pay to be number one, so we were surprised when it was number three. I can certainly report back to you, but as I say, I think that survey is still up on the Supreme Court's website.
Okay, so it is for the public, but they can go in and look
Yes.
at it. Okay, excellent, thank you.
So as I said, for district judges, we have to send a list of 3 to 4 to the governor, and then the governor makes his selection. And then subsequently, district judges are standing for election. I think we're up to about 51 district judges in the state now. All district judges run at the same time. And that's a non-presidential year. So there was a district judge election in 2022. There will be another in 2026. And those do not take place in November. Those take place at the primary time in May. So even though judicial positions are designated by the Constitution as being nonpartisan, they run at really the height of partisanship, which is the primary election in May.
Mr. Brady, I'm going to pause you for a minute. We have a few questions. So Representative Ehart, go ahead and start with yours.
Okay, thank you, Madam Chairman. Sir, you actually clarified it in answering the other couple of questions I had. But let me just go back for just a moment. On those who apply for these positions, then obviously money does play somewhat of a factor. So we primarily get public defenders who are applying and prosecutors, and very few from the private sector. And so as you have done your survey, is the survey something that is sent out to both the public and private firms as well?
Yes.
Okay, all right, so they're all responding to that. And then one last question on this, Madam Chair. So one of the issues, no doubt, in the private, I know would be financial. That might be probably the main one. But and that concerns me with salaries. I'm very well aware of that. If we want to attract, and it seems to me that those in the private sector usually have, I mean, obviously you can have the first ones, but those that we probably like to attract have been there for a while and probably know the law better. Is there a means of somehow, maybe that's up to us, but I'm asking you guys to engage some of the private sector, maybe not as judges, but maybe as mediators, or there's a lot of wealth and knowledge that they have that I dare say the judges don't have when it comes to the law. And since they're not applying for the job, how might we tap into the knowledge?
I'm sure. Talking about private attorneys who may be doing other types of work. Mediation is rather popular. And somebody that was doing that kind of work often does emphasize that as part of their application. And getting to the 5-year mark is not particularly difficult.
Right.
So it kind of depends on what you specialize in. We get candidates, especially for magistrate positions. They're all attorneys.
Oh, right.
We have had a couple of occasions. We just had one in the 2nd district where a magistrate from one county went to a different county. It's also happened in your district as well. But that's virtually all attorneys that are applying for magistrate positions. Some of them do it because magistrates are doing the type of work that they have done in practice and they want to do that. A lot of it is family law direct. So I don't think there is any one type of experience level that we'd like to see in people. We'd like to see it as varied as possible, because you're going to run into a lot of different things as a
Absolutely.
Okay. You follow up, okay, Representative Alfieri.
Thank you, Madam Chair. Mr. Brody, I'd like to ask you about the composition of the council itself. Is it a broad representation from across the state? You have 9 members. Where are the members from?
There's actually a requirement in the statute that there be some geographic distribution from that. The member that we just lost, Kathy Simpson, was living in Idaho Falls. Earlier this year, Liz Chavez had been serving for a long time in the council. She retired in January. She was from Lewiston. She had been replaced by a person from here in Coeur d'Alene, a citizen member. We have 2 citizen members also that are from Boise. Currently, both of the attorneys are from Boise. District judge was from Boise. Magistrate judge is from Paris, Idaho, the far southeast corner. But there is a requirement that there be some geographic distribution on that, and I know governors have always paid attention to that.
Senator Bjerke.
Thank you, Madam Co-Chair. Director Rudy, we had just appointed one of those new positions that we provided to the legislature as a district judge. Am I correct?
Yes.
In your estimation, is that maybe something that we could have voted on maybe in the next election or primary election versus the appointment process? Just your thoughts on that.
Mr. Brady.
Well, thank you, Madam Chair. So I think that's difficult because at the point in time when the Supreme Court goes to the legislature and says we need a new judge in this location, as they did this time when they said we need a new district judge in Coeur d'Alene and we need a new district judge in Idaho Falls. And that's done statistically, right? It's a bar chart. What's the average caseload for a district judge in this location? And when it gets sufficiently high, that's when they say we need a new district judge. So the only question then would be, how soon could you have an election to do that? Because there's a lot of work backing up in the meantime, and you already know you need a district judge. And it's hard to get. We do have senior judge opportunities. That's what we use to fill in when we have a vacancy until the governor does fill a position. But it's hard to get. I mean, there's a reason that senior judges are senior judges, right? They don't want to be working full time. So I would say that that's a difficult proposition, and that if it's a vacancy in a new position, I think that it needs to be filled as soon as possible because it's there because of need.
Mr. Brady, I'm sorry to do this, but we're going to have to move along just a little bit on your presentation. But the committee would really like for you to go over the, just briefly, the grounds for disciplinary action, if you would, and go ahead and just kind of give us a good overview of your presentation on that. If you do that for us, please.
Certainly. Statute that establishes the Judicial Council says the areas upon which the council has disciplinary authority and can take action. First of those is willful misconduct in office. Secondly, willful and persistent failure to perform duties. Third one is habitual intemperance, which is kind of old school. Lastly, conduct prejudicial to the administration of justice that brings the judiciary into disrepute. So as you see, these things focus on how a judge conducts themselves, and that's not just within a courtroom, but it's outside of the courtroom as well. The council also has the ability to recommend retirement in the case of a disability that's going to substantially interfere with the performance of duties. One of the things we do run into sometimes is the expectation that the Judicial Council can suspend or remove a judge. The Judicial Council cannot do either of those things. The Judicial Council does have some authority to recommend to the Supreme Court to take that action, but the Judicial Council itself does not have any power of suspension or removal. My next slide is basically the complaint process that we deal with.
Mr. Brady.
Yes.
Thank you, Madam Chair. Sir, I wondered if you could give me some examples of this, some of the things that might cause grounds for disciplinary action. Just some real life examples.
Well, fortunately, we don't deal with a lot of ethical misconduct by judges in the state of Idaho. I think we're lucky in that respect. I think it's a credit to the work the magistrate commissions do and the judicial council and the governor do. I can give you some of the recent actions that we've taken. Probably the most serious actions that the judicial council's had to take within the last few years have all related to workplace conduct by judges. Things that are said primarily towards court staff, things of that nature, and is not really involved in any action towards litigants at all. One of the things that does occur is, as we're talking about judicial conduct, it's how they conduct the court appearance for somebody. And we preach to judges that your watchwords are patient, dignified, and courteous. Because people are there on what is often a very unpleasant experience. And so we want judges to treat people in a certain way. And if they don't do that, that is something that can also become grounds for misconduct. I spend a lot of time listening to court hearings because I will get a complaint about what was said. And maybe what was said was inappropriate. That can be addressed with the judge. So it is really conduct based, and what is said does not in any way focus on the results of the judge.
A follow-up, thank you. So how many complaints do you get a year to the judicial council on judges? Just a quick series.
The average probably between 80 and 100 complaints to the judicial council. Those oftentimes do not go very far because they're complaints about results. And the judicial council doesn't, I have to explain this to people, the judicial council does not do law. We do ethics. We do conduct. So we're not looking at, we have no authority to enter into a court case and tell a judge, no, you were wrong, you have to change your order. Our only power is disciplinary. And so a lot of the complaints that we receive, our rules require a verified complaint. If we don't get a verified complaint, we send it back. We say it needs to be verified, and oftentimes people do not follow up after that. The number of complaints go away. I can give you.
That's enough. That's good. I think we're kind of late on time,
Yeah.
so I don't want to take up the time.
Senator Rucky, did you have a question? Are you good?
Thank you. I think, yeah. Did you call my name?
Yes.
Yeah,
Sorry.
thanks.
Sorry.
Thanks, Madam Chair, Mr. Brody, or Director Brody. So if I'm understanding right, I think what you were saying is if a litigant is dissatisfied with how the judge ruled on, decided the law and the facts, then that's not your purview in the judicial council. That would be an appeal to the next judicial level. But if it's about how the judge is behaving, whether they're fair, whether they've treated the litigants appropriately, then that may fall within the judicial council's purview if a complaint is made.
That's exactly right, Senator. We often, the vast majority of the complaints we receive are about results. As numerous executive directors have said before me, nobody wins in court and then ever complains to the judicial council. So it's been from adverse rulings that we get most of our complaints. And since they are complaints about the legal decisions that judges have reached, that's not within the purview of the judicial council. So most of those complaints get dismissed for that reason. But it's just not a matter that we can address. That's what appellate courts do.
Follow, Senator Rucky?
I do. Thank you, Madam Chair and Director Brody. The Code of Judicial Conduct, I see that it's on your slide, so maybe you're going to cover it in more detail, but can you just explain a little bit about the Code of Judicial Conduct and how it might affect a judges' ability, for example, to defend themselves against claims, about their behavior on the bench. Publicly defend themselves.
Well, Code of Judicial Conduct has 4 major canons. The first one is just rather all-encompassing about what a judge's role is in society. The second canon has many rules within it, and that governs how a judge conducts themselves on the job. Canon 3 also has extensive rules, and that governs how a judge must conduct themselves when they're off the job in their personal lives. And then the final one is Canon 4, and that's limited to the situation of election. Sets forth a lot of rules, and one of the rules that runs throughout is the judges, whatever comments a judge wants to make or explanation about why they've ruled in a certain way, a judge has to do that in court or in their written decision. They are not able to comment publicly about anything that is pending in front of them, anything that is likely to be pending in front of them. And those rules extend through to whatever election process that judge may be facing, whether it's retention or a potential contested election for a district judge. You cannot talk and make comment about something that has been in front of you, is in front of you, or may be in front of you, which really limits what judicial candidates can talk about.
Senator, you good?
Maybe just a quick comment. I've always thought this would make it really difficult to run as a judge for political office if you are an incumbent, because if you've made some decisions over the years, and you likely will, that are kind of unpopular and subject to being used in an election, you can't really defend yourself if you're going to stick to the ethical requirements. If you're going to be a good ethical judge and somebody's beating you up about some decision you made or a case that's in front of you, you can't defend yourself. You can't explain why you did what you did, or at least to try to do so, you're stepping in a minefield where an effort to defend yourself may result in violations of the judicial canons, which means another complaint could be filed against you and then used against you in the election. It would be really tough to run as a judge. I'm not saying they shouldn't run. That's the way the Constitution reads. I'm just saying there are some special considerations for judges in races, political races.
Thank you, Senator.
Yeah.
Mr. Rudy, we're going to have to wrap up because we're over on time. So I'm sorry if we didn't get to everything, but we thank you for your presentation and for answering our questions on that.
Thank you for the opportunity.
All right, we're going to go ahead and move on to, we have Scott Coleman, who's director of the passage to the left. Scott, if you go ahead and up to the podium. Introduce yourself for our record. So we thank you for being here today. This is an overview of child advocacy. So thank you, and thank you again, Director Rudy, for being with us today.
Thank you. Perfect. Okay, let me see if I can find my presentation here. My name is Scott Coleman. I'm the director of the Safe Passage Children's Advocacy Center. I'll try to talk to you all, but apologies in advance if I go this way. I'm used to talking to everybody. So let's see if we can pull this up. There we go. Okay, awesome. So a bit about my background and how it pertains to the discussion topic today. I've been in my role currently for 5 years, directing the Children's Advocacy Center here in Coeur d'Alene. Prior to that, I was a police officer and a detective for 13 years, so I do have quite a bit of experience and knowledge of how child abuse cases play out. So we'll go into what is a Children's Advocacy Center. I know that many of you know what a Children's Advocacy Center is. It's a hard word to say. It's a mouthful. Senator Bierke was instrumental in helping us statewide obtain some recent funding for Children's Advocacy Centers. Amazing stuff. So the legislature has been very supportive of us and the work that we do. But long story short, we are the community hub for child abuse investigations in our communities. So we have a CAC here in Kootenai County. There's a CAC Lilybrook in Bonner County. It's actually a family justice center. They're a little bit different, but they're pretty much the same. And we are the hub for those child abuse investigations. So anytime there's an allegation of physical abuse, sexual abuse, or other neglect, child homicide, child torture, anything like that will come through our doors, and we work it collectively as a team, as a multidisciplinary team. We are a child-friendly, safe place for children, and I'm going to read off of this because I didn't bring my glasses, for abused children and their families to come after they've experienced abuse. We provide neutral forensic interviews, which sounds fancy, but basically we ask non-leading questions of these children. As many of you can imagine, if you ask a 4-year-old leading questions, a lot of you are parents, things can go astray pretty quickly. So we stick closely to a legal protocol that holds up in court if we have to go to court and testify. We facilitate the multidisciplinary team. I do it here in Kootenai County. So our multidisciplinary team is mandated by Idaho law. I believe it's Idaho Code 16-1617. And that requires that child abuse investigation be dealt with by the multidisciplinary team so that kids are the hub of the investigation, aren't questioned multiple times, aren't subjected to additional trauma, so on and so forth. And we'll go into that a little bit more. We also provide medical exams to children. As I said, we have a medical exam facility in our CAC, which is located behind Kootenai Health, and we provide medical exams to children. Yesterday, we did one for a 2.5-year-old girl who had been tortured. So these are the kind of cases that we work. That's the kind of work that we do. We provide mental health treatment to any child that comes through our doors, free of charge. I've done a lot of fundraising so that we can just give kids mental health treatment. And then case review and management, that's a really important one. We work hand in hand with law enforcement, health and welfare, CPS, and the mental health counselors to make sure that kids are getting the treatment that they need. This is just a picture of our facility. I think we've painted since then. That's our facility dog, Lucy. Lucy comes to us from Bainbridge Island, Washington, and she provides emotional support to kids while they are providing their statement to us. She's also a courthouse dog, so she's allowed to go into court. I'll bring her in as her handler when kids have to testify in court at a grand jury hearing or at a jury hearing. Our MDT here in Kootenai County, again, that's multidisciplinary team. There are multidisciplinary teams in every county in Idaho per statute. Some of them are more robust than others. Ours does a really good job, I think, of getting along and getting the information that we need. There are 10 CACs across the state, I believe, 9. But every county is responsible for having their own multidisciplinary team. On our team, we have Kootenai Health that provides medical exams for children. We have Coeur d'Alene Pediatrics and Lakeside Pediatrics partners that provide medical exams to children. The Kootenai County Prosecutor's Office, Kootenai County Probation, law enforcement, so the Sheriff's Department, Coeur d'Alene PD, and Post Falls PD are all signatories on our memorandum of understanding. And then Idaho Department of Health and Welfare, CPS, is a very important member of our team, and our mental health providers. And that's really important to make sure that we're following up with kids after they've provided a disclosure. I'm going to breeze through that. Okay, so we'll talk a little bit about cases that end up at our CAC, just so we have an understanding for the purposes of today of how these cases get started. So we're kind of like the first step in the process when a child discloses abuse. Again, child sexual abuse accounts for roughly 95% of our caseload. And of that, about 75%, again, these are rough numbers, are intrafamilial abuse cases, meaning that a parent or a step-parent has committed sexual abuse on a child. So this is occurring within families. Vast majority. It's very rare that a child is sexually abused by a stranger. Child physical abuse, that's, again, the rest is about 5%. Child physical abuse cases, we range from small injuries to child torture cases. Neglect, so we have children that aren't fed, whole 9 yards. I won't go into the gruesome details. We're a witness to a serious crime. If a child's witnessed to homicide, we've worked a few of those cases. Or has seen, severe domestic violence, we'll interview those kids as well. Cases are referred to us from only 2 sources, at least in our Cooney County. Each county has their own policy on that. Ours, referrals must come from law enforcement or the Idaho Department of Public Welfare. We don't do referrals from private attorneys or family law cases because we'd be completely overwhelmed. And we don't do private forensic interviews. It's solely from these 2 sources, cops and protection workers. So our caseload here in Cooney County, we do about 250 forensic interviews per year. And that's just for Cooney County. We do provide courtesy interviews from time to time for surrounding counties. We do work with Shoshone, Boundary, Idaho County. We were working a lot of cases out of Lewiston, Moscow, but they've opened a CAC down there, which has been extremely helpful in Region 2. We also provide nationwide agency assistance. As you can imagine, if somebody commits one of these crimes, they're going to flee across state borders or out of the country, and sometimes, so we try to help out families that are local and provide a forensic interview for them. This is our team. Myself, Kate Capone is one of our forensic interviews and advocates, Aaron Pedro, and our executive director at Safe Passage is Amanda Creer, and Lucy. And just so everyone's aware, in Cooney County, the child sexual assault response protocol here, basically if the assault occurs within 72 hours, they're going to go to Cooney Health for a SANE exam. That's a sexual assault nurse examiner. Our CAC will be notified. Our advocates will go to the hospital, do a hospital response, and provide advocacy for that child during normal business hours. If it's outside of normal business hours, our parent organization, Safe Passage, will go to the hospital and provide advocacy. And then if 72 hours has elapsed, the family may go see a pediatrician, whether that's Lakeside Pediatrics or Coeur d'Alene Pediatrics. Some of the successes we've definitely improved our MBT collaboration, which is extremely important. Everyone on our team communicates well, gets along, and we all try to put our egos aside, as you can imagine, to try to do what's best for kids. We've recently received full accreditation with the National Children's Alliance. We've established no-cost mental health services, no-cost medical exams, established a courthouse facility dog program. And then recent funds, as I mentioned, were acquired through the Idaho state budget to supplement VOCA cuts, meaning that the state of Idaho has stepped up to protect Idaho kids, and legislators heard our call and said, hey, we're going to give you guys more funding to do the work that you do. So thank you to all of those who helped with that project. Some of the challenges and needs, and this will be pertinent to our the work we do today. Reduction in child abuse medical exams. We are, as you can imagine, it gets pretty expensive to provide medical exams to every single child at no cost to the child. That's something we continue to do. And it's also puts a kind of a burden on sort of like Jeff was talking about before me, trying to find judges. You have a lot of pediatricians in our area who are extremely qualified. They make really good money doing private practice, and they're packed. They have so many kids that they need to see in their own private practices, and a lot of them don't have the capacity to come do the exams or provide testimony for, and so on and so forth. So that's the challenge there. But we're working through that. We're trying to have a dedicated child abuse specialist for Kootenai County through Kootenai Health. Problematic sexual behaviors. This is a huge problem in the state of Idaho. A lot of our cases, again, intrafamilial, occurring between family members. A lot of it's generated by access to pornography, and we're seeing siblings offending on other siblings and exhibiting problematic sexual behaviors. In the state of Idaho, we don't really have a solid treatment program for problematic sexual behaviors. It's becoming a huge epidemic. That's something that I think stakeholders from across the state, private sector, public sector, everyone needs to work together to figure that out. We have to have a more robust system to deal with problematic sexual behaviors, teens offending on other teens. That next one's a little too vague to talk about. Okay, so yeah, there has been some legislation that does not allow medical treatment to be provided to children without specific permission from a parent. That's been hugely problematic for a number of reasons. One of which is I think there was a case at Community Health recently where a kid broke his femur in a soccer tournament, and he was hospitalized at Community Health, but they couldn't give him Advil because his parents weren't on the flight. So that's a problem. For us, from an investigative standpoint, if we have a parent that's accused of sexual abuse, we cannot perform a forensic interview, basically just an exploratory interview on that child without a signature from the parent. And if the parent is the perpetrator, that's a problem.
Representative Ehart.
Thank you, Madam Chair. I just want to compare that, given that I'm the author of the legislation, that's entirely not true. And we will add more clarification, but it specifically allows law enforcement to do that.
It allows law enforcement.
Yes,
Correct.
it does allow law enforcement. And in an emergency situation, actually, I think we could have been sued for that. When you cannot get a hold of a parent, allows for a child to be treated. But aside, I just want to make sure that everybody here is not moaning and groaning, thinking, sometimes I think they try to make points by not doing that. The law absolutely allows for that. Just, given that I'm the author, I want to make that very clear. Thank you for saying it.
Yeah, I personally feel there needs to be some clarification, because law enforcement can provide a forensic interview to a child who was sexually abused by a parent or a family member.
Yes.
However, we can't at a CAC. We're not law enforcement. There's been a law enforcement hesitancy to shelter child victims. An officer was sued in Ada County recently, and that was.
Gannon.
Thank you, Madam Chair. And I have a follow-up question to Representative Ehart's question. So the answer was that law enforcement could conduct such an investigation, exam or interview. Can law enforcement authorize you to conduct the interview? In other words, sit in on the interview, that kind of thing?
No, law enforcement cannot authorize us to do the interview. Law enforcement can conduct the interview themselves, and we can let them use our facility, but it can't be a forensic. So law enforcement does have trained forensic interviewers. They prefer to use us because we're completely neutral.
Representative Gannon, do you have a
Thank
follow-up?
you. No.
Madam Chair, I've got a quick question.
Go ahead, Senator.
And actually, it's for Representative Ehart, because I was trying to, somebody asked me about this, and it seems like we tried to make a modification. We came back this year to modify that bill that we're talking about that requires parental consent. Am I remembering that right? Did we come back and try to do a modification of the bill? And if so, was it successful?
Representative Ehart.
Madam Chair and good Senator, that we needed to make a few other changes when it got to the House. Unfortunately, June rules decided that they weren't going to hear it at that time. We also wanted to remove, if you recall, the section about, anyway, we will bring that back with the corrections that I think you will like, clarifications, though we don't feel it was me, but we are bringing those back, and we're going to bring it back at the very beginning of the session and put it into effect ASAP. So I think you'll be pleased with that. But I still wanted to say the intent of the legislation was already there for this, but you are correct, Senator, and we will bring that back at the very beginning and get that fixed.
Thank you. That's all I have.
And if I may, that parental signatory situation does pose some more challenges if modifications can be made for the medical portion as well. So if we have a child that's brought in for a sexual assault examination, say you have a 16-year-old girl that discloses she was sexually assaulted by her father, it's my understanding they would not be able to provide a sexual assault exam without a parental signature.
No, not true. Sorry.
Okay.
Yeah.
Okay, we'll move on. We'll move off of that. So again, the law enforcement hesitancy to shelter child victims. We've had our law enforcement was recently sued in Ada County for sheltering a child victim for a neglect case. Forget the term. Whatever the immunity a law enforcement has, the court decided that was not applicable to this case, and the officer was sued directly. So you do have a lot of hesitancy from law enforcement to shelter child victims. Not really sure what we can do about that. If I believe that if the Attorney General had a standard child abuse investigative protocol that could be applied across counties all across the state, that's basically a checklist of evidence that needs to be collected, best practices and things like that. I believe that would be very important and help law enforcement get to the bottom of these cases and get good convictions. I also feel that, and I brought this up to Cardiff, which is the governor's task force on child abuse. It would be important to identify the problem first. So identify conviction and resolution rates across the states in child abuse cases, and in each region to get a clear picture of needs and gaps. And then finally, I guess my last testimony would be a hearsay exception for child victims. When we do our forensic interviews, they're not admissible in court in the state of Idaho, and that's because they're considered hearsay by the court. We in our county try to do grand jury hearings so that the children don't have to confront their abuser in court or be cross-examined by defense attorneys in court for that grand jury hearing, and that gets the case to move along to the next step. I feel like it would be a wonderful thing if we had a hearsay exception for child abuse cases, maybe it's capped by age or whatever, for preliminary hearings only, so that child doesn't have to go to court multiple times to confront their accuser.
Okay, Representative Uhart would like you to repeat that last portion that you just said.
Sure. So the hearsay exception for child abuse victims, again, the forensic interview, we're doing it in a safe environment, and the kids are more willing to disclose when they're feeling safe. So ideally, we would love to have a hearsay exception for child abuse victims in preliminary hearings to keep them from only having to, so that they only testify once in court, and that's at a jury trial.
Thank you. Okay. Do you have any other questions for Mr. Coleman? Representative Chair Scott?
Thank you, Madam Chair, and thank you, Mr. Coleman, for testifying today and bringing these ideas that we should look into. My question is back where you were saying that the only two sources for referrals that you can use are from law enforcement and Idaho Health and Welfare.
Yes.
And what we've dealt with a lot as we're looking into this family court situation and custody battles is two different things. Maybe where the judge has placed the child in a home where they're actually being sexually molested, but that person has custody. So we're dealing with that. And then we're also dealing with, obviously false accusations. One spouse is like, well, they're sexually abusing. So how we're trying to figure out some types of solutions. And I'm just wondering if you have any input on, obviously they can't come to a center like yours. We have the CPS that don't want to hear it because they're like, we don't want to mess with it because it's in custody court or family court. We have doctors that are ignoring it because they know it's in custody battles. How we're trying to look at ways that you can address sexual abuse of children. And I just wonder if you have any insight, or if you made a comment that it would be, if we had opened this up to other than law enforcement and that into the courts or family courts, we would be so busy.
Yes.
Can you expand on why, and then maybe if any of your suggestions you have, Mr. Coleman?
Yeah, so the reason we have, so basically any allegation of sexual abuse, at least in our county, the way it sits now, will be brought to our CDC at some point or another. If law enforcement suspects that there's sexual abuse, or if there's a credible allegation, that they will bring that child to us. If a case moves beyond that point, say it's investigated by law enforcement or health and welfare, and it's found to be unfounded, or there's not enough evidence and the prosecutor can't prosecute on the case, and things sort of go back to status quo within a custody hearing, have to move into the civil arena, and then it would be up to the attorneys to work that out, unfortunately. As far as capacity goes, I think if we were to do, well, there's a few different factors there. So as far as capacity goes, if we were to do follow-up on civil cases, I mean, we would, if not doubling, probably tripling our caseload. And then we'd be interviewing children multiple times, which is really against best practice. We'd be asking legitimate questions over and over and over again, exposing that kid to more trauma, if that makes sense. I don't know if that answered your question.
Sorry. Thank you.
Sorry, I don't have a solution for that, unfortunately.
Senator
If I did, I would tell you.
Okay, Senator Carr.
Thank you, Chairwoman. And Mr. Coleman, my question is, how many child advocacy centers are there throughout the state? Do you have an awareness of that?
I believe there's 9. Might be 10, because there's a new one that just opened up. I think it's 9.
Okay, Representative Gannon.
Thank you, Madam Chair and Mr. Coleman. So, how are you aware of any situations where a child has been placed in a home where the parent in charge has sexually molested that child?
Off the top of my head, it's hard for me to say definitively. Based on my opinion on cases at work, yes.
Follow up, Representative Gannon.
Thank you. Madam Chairman, Mr. Coleman, does that yes apply to a person who may have gone through the court system and been found guilty or culpable of the sexual molestation charge?
Not off the top of my head. If someone has been convicted of a sexual abuse charge, there are great protections in place to keep them away from the child. The problem is one of the biggest challenges, I think, for all of these cases, and it does apply to the civil side as well, is gathering the appropriate evidence.
Right.
That can be very hard to do on these cases. But if someone has been convicted criminally, I can't think of a case where the courts have said, we're going to put you back in the home with this abuser. I have heard of cases where there are siblings, so people under the age of 18, minors, and that gets pretty weird and challenging sometimes. So you have mixed families. One, say an older brother offends on a younger stepsister. That happens pretty frequently. And the older brother has been convicted and he's not supposed to be around that kid, but he happens to pop in and out of dad's house when she stays there from time to time. That does happen. But when it's an adult offender, I can't think of one off the top of my head. That doesn't mean it doesn't happen, but I can't.
And one other question, if I can, Madam Chair. Because I think this is very important, particularly in view of the testimony that we heard at the last meeting. Madam Chair and Mr. Coleman, so your initial answer was yes, you had heard of children being placed in a home where the parent or the person in charge was a sexual offender. Could you amplify on that, on how that could happen? And is there some kind of something we should be looking at to address that issue?
Sure. So I think in the context of that answer, I was referring to cases that haven't been adjudicated, cases that are being investigated, cases where there's not enough evidence to support a prosecution of the suspect. In those cases, yeah, unfortunately, the kid can sometimes end up back in the abuser's home. The only way to remedy that is to, it's really hard. You have to get the good evidence on the case right off the bat. That's why there's a law dictating how we work these cases as a multidisciplinary team. And it's really important for investigators to get the crucial information right off the bat. It's tough in intrafamilial cases where the offenders are family members. Again, that's the majority of the cases we see. some of the challenges that come up is the ability to do a forensic interview and to explore with that child, like what's happened to you, the ability to do the pediatric interview. On a lot of our cases, when kids come in for a medical exam, the pediatrician will go back into their history, into their medical history, and find out that, hey, this kid's been brought in by dad for birth control, or this child tested positive for herpes. That's all very powerful evidence, but we don't get access to that evidence unless we can do a medical exam at our facility.
Thank you. Thank you.
Yes, Madam Co-Chair and Director Coleman, thanks again for the work you guys do. Thank you. Very much appreciated. My question is, when these two systems kind of collide, is there a time where there's a child custody case moving forward that is the impetus or the beginning of an investigation from your point of view that it was brought forward because of the child custody case?
Yes, absolutely. Yes.
Madam Co-Chair, yes. Do you have any idea of the percentage of how often that happens?
Educated estimate, I would say approximately 30% of the abuse cases, and again, those disclosures typically come out when a child comes home from a custody visit with the former spouse and they have injuries, or the child makes a disclosure that something happened. So yeah, that does kind of spark things from time to time. I don't know if that does through enough. Perfect. Thank you.
Mr. Coleman, we thank you for being here. We appreciate your presentation and thanks for being with us today.
Thank you.
Okay, we're going to go ahead and go with Sheriff Darrell Wheeler, who's here. He's on the job today. So, Sheriff Wheeler, we welcome you to the committee and we'll be talking to us today about policies. And go ahead and state your name for the record and proceed.
Good morning, Madam Chair, Bonner County Sheriff Darrell Wheeler for the record. Thank you, Madam Chair and committee members for the opportunity to come before you this morning. I have served as a police officer for over 39 years. I've had the privileges of serving as the elected sheriff in Bonner County since 2009, and I am now serving in my 5th term. I do have to retire sometime. Before I start with this, I want to answer one question that Mr. Coleman had and you had. There was recent legislation about what happened in Ada County. There's been a recent ruling in the Ninth Circuit of Appeal, Ingram versus Mosser, which was declared in January 23rd to 24th. We police officers can no longer, based on probable cause, just remove a child from a home. We have to go get a search warrant and a warrant from a judge to remove that child from the home. So it takes that vicarious liability off of the officers and the police departments and the sheriff's offices and their employees by doing that. So that was, I think, was a good ruling and for that. Also, before I start, I want to listening to some of the testimony. Bonner County has a lot of sex cases to the fact that we are number 3, not per capita. We are number 3 sexual offense filings in the state of Idaho. We have a lot of cases. So I'm coming here with a lot of experience on how we as the sheriff's office and our team deals with that. But let me just get on because I know time is limited and I just want to get to the crux of things. This morning, I just want to discuss some policy priorities to be considered for the 2026 legislative session relating to child custody and domestic relations. I do believe that the most critical action you can take in the next legislative session would be to add coercive control as an element to domestic violence in Idaho Code 19-918. The victims of coercive control are hidden in plain sight. Their scars are invisible, but I believe they make up a majority of the high conflict divorce, and custody battles. A crisis or physical altercation can bring these cases to light. However, this form of extreme cruelty is not recognized as a crime in Idaho. This must be changed, hopefully this next year. The second priority would be to limit, if possible, the number of motions one party in a child custody battle can file against the other in a case. This is called vexatious and abusive litigation. It is meant to bankrupt and humiliate the other party so that they will give up. It's one tactic of someone who is guilty of coercive control. My third priority would be to make sure that all those who are involved in protecting children, to include law enforcement, the judges, and health and welfare, have the resources to make this happen. Training costs money, but it's obvious to me from the testimony that I've heard in your July 7th and today that those who are charged to protect these victims need to be properly trained in handling these domestic violence. Little point of law, in 2019, the Ninth Circuit Court of Appeals had a ruling of Clark State versus Clark. The Clark held in this agreement with common law that the framers of the Idaho Constitution understood that Article 1, Section 17 prohibited warrantless arrests for misdemeanors committed outside the presence of law enforcement. Since that ruling, police officers can no longer make arrests for misdemeanors not committed in their presence. Those include assault, battery, first-degree stalking, domestic violence, second-degree stalking, and violation of court order. It also includes any other misdemeanor that was allowed and qualified in other statutes, DUI, hit and run, those others. We can no longer make those kind of arrests. And I believe that properly trained law enforcement could and should inform victims of domestic violence that they can make a citizen's arrest. Too often, the victims of domestic violence have been so controlled by the perpetrator that they minimize the trauma they experience before the police arrive and they refuse to arrest the offender. Because of this State versus Clark ruling, police officers can no longer make probable cause arrests, and they are dependent on a traumatized victim in making a citizen's arrest. Those are some of the obstacles that we in law enforcement have been dealing with. So this morning, I offer you a commitment to work with you in the committee to find solutions and changes to keep our children and victims of violence, domestic violence, safe, and especially raising the standards of training for law enforcement, for judges, and health and welfare. And in closing, I want to make a few comments on discussions and questions raised on the last hearing. The subject of perpetrator making false reports of child abuse, abandonment, and neglect of law enforcement, health, and welfare can be held accountable. And this is codified in Idaho Code 185415 in such false reporting. There is a statute. If that is happening, I encourage those victims to make those reports to local law enforcement. At least in Bonner County, we will investigate and refer those cases to the prosecutor. And I want to also, and this addresses Mr. Coleman's, there is now a reporting requirement for health and welfare to share the new law enforcement within their jurisdiction any report of child abuse made directly to their department. Idaho Code, not Idaho Code, but there was that case that I cited, Ingrid versus Maurer, which is the Ninth Circuit Court of Appeal, requiring us to do that. And I'm not find it here, but now the laws have changed so that to the point where if there's a new claim by health and welfare, with someone is now wants to make a claim that they're being abused in a foster home, and health and welfare is notified it, they're required by law to notify law enforcement. We're required when we have cases and they likewise with us. So if that is not happening, I'm encouraging you to report those people that are not following the law and making those disclosures, because we have to be accountable to each other. We have to follow the law, and even primarily, even more importantly, we need to keep those children safe and get them out of that situation. And lastly, Representative Ehart asked if there was a sharing of information between law enforcement agencies and the way in law enforcement we can investigate our involvements. And yes, there is. We have been using a program called CopLink, and now it's been taken over by Crime Tracer. And we have the ability to communicate with over 2,500 law enforcement agencies throughout the country, and those in California and surrounding. And by using this, we can check our databases for reports, for contacts in those agencies. Some agencies, it's a program that they have to purchase and fund, but I'm hoping that the agencies around the state and maybe even the governor will fund programs like that so that we can communicate with each other's agencies. So, Madam Chair, thank you for the opportunity to address the committee, and I stand for any questions you may have.
Appreciate it.
Thank you, Madam Chair. I had two questions. The first, with your data sharing, are you guys connected in with the fusion centers? Sure.
We are connected to the fusion center, but we don't have a direct link. The nodes that are set up, and these are just information nodes, are set up by contract with the agencies, and so we can't just go into the fusion center and see what they're working on.
Thank you, Madam Chair and Sheriff Wheeler. My other question is, I didn't know that I completely understood what you were saying about the reporting, and if I'm going to reiterate what I thought I heard, and you tell me if this is correct. So you said something that if CPS gets a report of a child being abused, they have to let law enforcement know?
Absolutely. If you look at Idaho Code 16-1605, last year there was an amendment made and added that law enforcement and local law enforcement agencies with jurisdiction in the area where the report occurred shall be informed by the department, and any other report made directly to the department. So that new law came into effect. So if they do get a new report, they're obligated to report that to the jurisdiction that they received that report.
Follow up. Thank you, Chairman and Sheriff Wheeler. So would law enforcement be bound to investigate, or can they just choose to ignore it?
Sure.
So this is the old adage, okay? I'm going to tell you what happens in Bonner County in our jurisdiction.
Okay.
And I hate saying this, but other agencies operate differently than we do. And for me, I don't go to Yokes and complain about the service at Safeway. So I don't know what's happening in other jurisdictions. If they've taken an oath to fulfill their responsibility for public safety, they should, as we do. We take every report coming in as serious, and we will investigate it. You must understand too that there's the separation between the civil process in family court and then the criminal process and investigation we do. Sometimes they don't even meet. We do our investigation at the front end, but then once they get to court, if there's new allegations, if they're not reported to us, then we cannot investigate it. So I'm hoping there would be some coordination or maybe some change in the law, so that if there is some disclosure in the civil courts, that those judges will have to disclose that to law enforcement so that we can investigate it. I just know that in Bonner County, we take that very serious, and we will investigate it.
Representative Ehart.
Thank you, Madam Chairman and Sheriff, good sir. Thank you. You've been most informative in very quick and precise way. And so, a lot of questions, and I would like to contact you another time too. But just going back, one of the things I know in our first hearing that was very it's been bothering me is this idea that, you know, we have parents and they'll wait their 30 days or longer, they'll wait to have this hearing and then, oh, that hearing's gonna be moved. You don't get to see your kids because another motion to be filed. And so you had said, you know, that if I heard you right, it would probably behoove us to, and it is for the point to both delay and bankrupt. This is big business. I say bankrupt, but you know, drain it full of money. And of course, big business. So in your estimation, you've seen it enough that you think that it would be important for us to do something about limiting motions. And then the question you asked, answer that if you would. And also, sometimes those motions, and I think you're addressing this, but help me make sure I hear it clearly, also include then either sexual or some sort of abuse, right? And that's why, so under current law, as you understand it, because you said you take it very seriously, but it doesn't have to be referred to the police if that allegation is made in court, does it? I mean, it seems like that's just handled in the family court. So if there's an abuse allegation, shouldn't that then be criminally investigated?
Sure, Wheeler.
Madam Chair, Representative Eric, absolutely it should be. We do not, I said law enforcement do not participate in these civil proceedings. A lot of times they're closed.
Yeah.
So if those disclosures are not relayed to either health and welfare, who are our partners, or law enforcement, they go uninvestigated. So it's incumbent on one of the parties, if they are, once they exit court, if that is disclosed, they should make that disclosure. But then on the other hand, it's a two-edged sword, because a lot of times those disclosures are made because you have a coercive parent who is making these allegations that are totally unfounded. And they're just trying to keep that hearing going and creating a delay in the ruling from the court. So we have to judge each one independently.
Yes, Madam Chair. So as you're saying that, exactly some of the things I think all of us are wondering and feeling. And so if allegations are made and that hearing is then put off, and again, shouldn't that be the judge's responsibility to report that? I mean, it comes to the judge, it shouldn't be. Let's get a nerve there.
Madam Chair and Representative Ihart, is that a rhetorical question?
Thank you. Hey, Representative Alfieri.
Thank you, Madam Chair. And Sheriff, I want to go back to something that I think I heard you say, which is that law enforcement cannot arrest for misdemeanors not committed in their presence. So let me walk through this and tell me if I'm right on this. If you're investigating an allegation of child abuse and your deputies show up and they see that the child has bruises on them, an obvious example possibly of some abuse, you're not able to arrest. Is that right?
Madam Chair and Representative, in that case, if there's bruises of this child, that's going to elevate that to a felony, so we can. But if it's just a straight domestic violence and there's no critical injuries, there's no injuries, I mean, it's going to be incumbent on the victim or another witness who actually witnessed the crime to make a citizen's arrest. We as police officers, that has been taken away from us, so we cannot do that on probable cause.
Yes, Madam Chair, thank you. So if we're talking about a domestic violence, and so we're asking that spouse, that partner, to make a recommendation of arrest, that's not likely to happen, is it?
Sure.
Madam Chair
And
Representative,
obviously.
No, it is not likely to happen, because if you understand the circle of domestic violence and what is the abuse and the belittling and what's happening in the life of that parent, they minimize that experience. When the police show up, they say, "Oh, really, it's not that bad. I just have a little redness to my neck and I'm not really hurt." And I just want them to leave tonight. And it's at that time we encourage them to make that arrest. But if they don't, all we can do is make a referral to the prosecutor's office, and with limited evidence, and then without the testimony of the victim, they fail to file charges. And to that point, somebody can be part of an investigation in domestic violence, have no criminal investigation or referral to the prosecutor's office, not be found guilty of that. But on the other hand, which is a good perspective to the civil, you can have a civil proceeding in family court, and the judge can make the determination, absent a criminal conviction. Well, I found probable cause that there was a domestic violence, and we are going to grant that protection order. So those are the kind of the two theaters, and what happens in civil court and what happens in criminal court.
Thank you.
Thank you so much, Sharon. We really appreciate you being here with us.
Thank you.
Okay, we're gonna move along. We have several individuals in health and welfare. Crow and Andy Blackwood, Maggie, they're with us on the stream tonight. So we're going to go ahead. Monty, are you there? Okay.
Morning, Madam Chair, members of the committee. So good to be here today. Can you hear us okay and see the slides?
Yeah, we can hear you, and I should find our meeting brought up. Yep. Okay, there we go. Thank you. Go ahead.
Okay, thank you, Madam Chair, members of the committee. Really thrilled to be here with you this morning. My name is Monty Pro. I'm a Deputy Director here at Health and Welfare, supporting youth safety permanency, supporting early learning and development, and a handful of other child-serving programs. I'm thrilled to introduce Andy Blackwood, one of our amazing bureau chiefs here in the department, as well as Maggie Morrison, our amazing Region 1 program manager, who will also assist with the presentation. And I understand we're going to do the next slide operation, so I think Andy's up next.
Yes, thank you, Monty. Madam Chair, members of the committee, we wanted to talk just for a couple of moments about different pathways into the child protection system, how children are removed from their homes. So at the top of the slide, you see pathway A, and this represents approximately 40% of the cases of children who are removed from their home. So this is referencing law enforcement using the ability that they have, seeing imminent danger. Certainly our last presenter was accurate. A Ninth Court ruling changed or further defined what imminent danger is and should look like for law enforcement. It made it a little bit more confining than it has been in the past. But imminent danger, then that case is presented to the prosecutor, who makes a decision about if they're going to file the case. And then, we end up at the shelter care hearing. During this time, the department has a placement role only. So we are expected to place. We have emergency custody, which gives us really only ability to place children until you get to that step 5, where the court sees and has a chance to rule on whether or not that removal was appropriate given the circumstances at the time. So pathway B is 60% of cases. And this may be things that come into our child safety hotline. And then our staff go out and they do their assessment. They interview children, they interview parents, they interview collateral contacts. A lot of times they also do coordinate with law enforcement. But if there isn't an imminent danger element to the situation, they coordinate with the prosecutor. From there, they provide the prosecutor a report of what's going on with the family. And then the prosecutor decides if paperwork will be filed. Then a judge would see that paperwork and make a determination about whether or not that removal is going to happen. And then again, until the shelter care hearing in step 5, even with that somewhat different process, the department only has placement authority at that point in time as well. Next slide.
Thanks, Andy. Great job. Really, the next few slides, we want to communicate what we've done in the department in the last 12 months. Under Director Adams' leadership, we did a casting call And we said back in June of 2024, we want to hear from you. If you're invested, involved, connected with the child welfare system in the state of Idaho, we want to hear your story. We want to know what's working well, and we want to know where we can innovate. And so on your left side of slide 3, we have who we visited with over the last year, roughly over 150 stakeholders, a little bit more now, across this spectrum. What we learned may surprise you. It surprised me a little bit. What I learned is that roughly 95% of kids in Idaho will never have their name known to the child protection system. 99% of kids in Idaho will never have 1 hour of stay within foster care or shelter care hearing. I think that's a testament to Idaho's families. I'm really proud to share that. That's one of the things that keeps me going as a parent. And in this space, I just really want to impress upon you and the committee, Madam Chair, how awesome and amazing most 99, 95% of our families are supporting their own children. One of the things that we learned from them was how important it is to provide resources for families. This is biological families. So one of the big things we asked this year, the governor's leadership, legislative leadership, many of you in the room today supported our prevention efforts, resources to keep families whole. That's one of the things we learned early and frequently in our visits with bio parents is if they only had this resource, that availability of this outlet for their family dynamic, that may have made the difference. And that really led us to where we came to the conclusion that we really needed support and help in this role was visiting with those biological parents. On the foster family side, what we heard from them is the need to feel part of the team, the need to be communicated with, and we took that to heart. So what we've done is many different things. We updated our amazing. You can't see this, and I'm going to point at the camera, but we created a guide to fostering in Idaho, and one of the critical pages in that document is it outlines areas that our staff can freely share with foster parents, and our communications that are maybe limited based upon federal rule or state rule. Questions that we might get from foster parents historically would be something to the effect of, how are the bio parents doing in substance use treatment? How are the bio parents doing with finding a job? Those sort of things are not going to be able to be relayed, and putting them in that document that I just presented allows both our staff and our amazing resource families to be on the same page. So they know that there are certain things that we just can't share. We're about ready to create a biological version of that book, and it'll have similar conversations, because you can probably imagine in the event that a youth is removed from a home for a short period of time, as short as time as possible, that biological family is also going to have questions about where their youth is staying, where their child is staying, and we want to be on the same page with them as well. One of the other things that I want to bring to the committee's attention is what we learned with visiting with over 150 stakeholders in the last 6 months or so is the complexity of the system, the concern about lack of transparency across the system, whether that's LE, prosecutors, health and welfare, across the complicated system. And that's really all about the checks and the balances that we try to explain. And where we have a couple slides later that we're going to talk about how we try to share that with biological families. We try to share that with foster families. You may be familiar with biological family advocacy groups that we interact with. You might be familiar with foster family advocacy groups that we interact with. We try to keep them on the same page for sure, and that's what the next few slides are going to represent. And I think, Madam Chair, there may be a hand up.
Yes, committee, there is a handout that you have, and so we appreciate you getting that to us. Thank you. Oh, sorry, hand up. Sorry, I thought you said hand out. Okay, yes, go ahead. Did we have a question? Nope, we're good.
Excellent. Next slide, please. So you heard me mention that as part of the outreach to stakeholders, one of the concerns they had was transparency in the process. So in the last 12 months, we made an update to IDAPA that ensured maximum transparency as possible. I shared with you the document providing guidance to staff on what can be disclosed as maximum amount as possible. Consistent with legislative directives. You're always aware of your Idaho code obligations or opportunities as state officials to receive access or special access to records. And this last bullet surprised me. As part of the conversation we want to share with you today is the amount of public records. This is just child welfare. In the last 12 months, roughly 2,500 public records requests have been fulfilled. We're absolutely pleased to do so. The amazing Jared Larson's now in charge of that operation, and he's doing a great job making sure those are fulfilled in a timely manner. So we just wanted to make sure that you had a slide that talks about how we're really trying to meet where the bio family advocates and the foster family advocates really want us to be, which is, transparency in the process. And here's what one of the things we're able to offer. Next slide, please. So this is sort of a pivot point to our conversation today. We wanted to share with you, Madam Chair, members of the committee, the interplay between family law and child protection courts. Roughly 450 safety assessments were ordered to Health and Welfare from a family law judge. This represented roughly 5% of our total assessments throughout the year. You can see in front of you the results of those the safety assessments we conducted. The next bullet talks a little bit about how the court-ordered safety assessments from family court are slightly different than what we generally get off of that safety hotline that Andy talked about earlier. There's just some regional differences. We see a little less by way of removal than we normally see by the sort of phone call or child hotline review or law enforcement review. So that's, I think, interesting to note for the committee. One last thing to note here is in 2023, Idaho Code 185415 was added, which ensures that if there's a false allegation and child protection is involved with that, it's a misdemeanor. Again, that was added in 2023. Next slide, please. I talked earlier about the important things we learned from interacting with stakeholders. One of the ways we're trying to ensure that we're on the same page is just a conversation with our stakeholders when they ask us about what happens in court or why isn't this or why isn't that happening. My judge did this, my public defender did that, my prosecutor did this. It's to refer back to judicial rule. It's to refer back to what's already in place and just to reemphasize that the courts are following the law or the rule outlined today. And one of those things that we've heard from families and advocates is the unified family court concept, which of course is allowed and encouraged in Family Judicial Rule 106. But sometimes sometimes the judge can't be both sides just because of the sheer volume. And so sometimes, depending on the jurisdiction, those cases are broken up. So that's what this is sort of referring to. And many of the advocates that we've talked to, both on the biological side and the foster family side, have referenced this as an interesting note that happens in Idaho. Next slide, please. We're going to pivot to the law. Again, similar to the conversation from before, we interact with foster families and bio parent advocates many ways. One of the things that we've been doing is really reaching out and trying to encourage people to sign up to be a foster parent. What you see happening, though, is people move into the state, which is probably not a surprise to this committee. People move into the state. They were foster parents in another state. They come to Idaho, go through the process, become an amazing foster parent for an Idaho child in need. And then they come back to us and they say, wow, in my state, this was different. In my state, we did it this way. And so we're trying to redirect them back to their guardian ad litem. We try to redirect back to their attorney just to be consistent with the law And so all parties can be playing off the same hymnal, so to speak. We're trying to ensure that folks know that each state is a little bit different in the way they handle this, and that our courts are following the law as prescribed. Next slide, please. One of the things we also share with our bio family advocates and foster family advocates is an OPE report from 2024 that just breaks down the differences in the jurisdictions, and our Idaho courts follow the law, follow the rule, but they're just different from where you may have come from. So this report sort of outlines that. And I think, Madam Chair, I think the committee was provided a copy of that report just since I referenced it.
Yes, I believe we did. Yeah, we do have the copy of the report. Yeah, it's this one that has, it looks like this. Yep, thank you.
Excellent. Thank you, Madam Chair. And now I want to popcorn over to Maggie, who's going to walk through what we really are excited about, which is reunification, which is getting kids and families back together. And that's really the momentum where we're heading in Idaho. If there has to be a removal, how short can we get that? And Maggie's going to jump in here and talk a little bit about reunification and give a real life example from Region 1. So Maggie, you're up. And next slide, please.
Thank you, Monty. Can you hear me okay?
Yeah, go ahead.
Okay, thank you. So reunification is when the courts place a child back with one or both of their parents or legal custodians. So with the department, and we're working reunification, our priority is what the court has told us to do based on the safety of that child and based upon legislative guidance such as the Child Protection Act and the Idaho Parental Act, and any other legislative guidelines that we have. When we're looking at reunification, we work with the family, and in that time, we build a case plan with them. This case plan is brought to the court, and the court orders the case plan, and that helps to dictate what resources and what services we're going to help put in place based on the safety concerns that brought the child into care. In the state of Idaho, about 60% of the time children are reunified with their parents or legal custodian. We are averaging around 11 months of time spent in foster care before they're reunified. And on average, we're reunifying about 51 children a month with their families. Next slide, please. So I wanted to give you a real case example. This is a real family from Region 1. That we successfully reunified. We were from opening to close. It was about a year that this case was open with us. So it's a success story of a young family and how the community supported mom's recovery and support with reunification. So in this little family, we have a mom. She's 25 years old, a dad, he's 28. And then we have a child, she's now 3, but she was about 21 months when she was removed and placed in foster care. So the removal of the child was in December of 2023. Mom and dad were living with family members when they were both arrested for active substance use and drug paraphernalia being found in the home around the young child. There was no appropriate caregiver for the child, so law enforcement found the child to be in imminent danger and the child was placed in foster care. That's when we came in. But I wanted to give a little history because a big part of what we do is we look at their trauma history, and it helps us to understand where the family's coming from and how we can help them. So the history on this one, mom was struggling with illegal substances since about the age of 9. She comes from a family who has also used substances and exposed her at a young age. She has been an addict most of her life and had an extensive criminal history related to her substance use. She has been on probation and outpatient services, but had limited success in those services. Mom did have a period of time that when she was sober when her daughter was born, and then she moved back in with her mother and stepfather. She relapsed on meth and was arrested on a parole violation. Mom struggled with childhood trauma related to her own mother's substance use. She experienced chronic neglect as a child and was in and out of her mother's care. This has directly impacted mom's ability to perform basic tasks and maintain stability in her emotional health. It has also led to a pattern cycle of ongoing substance use. Mom is diagnosed with panic disorder and depression. She was a single mom and she only had this one child. She's been in an on and off again relationship with the child's father, who also struggles with substance use. Dad has a significant history of substance use and a family history of substance use. He was living with his mom and she was arrested for drug charges right before the child came into foster care. He has a lengthy legal history starting when he was a juvenile and was on felony probation. He struggled with healthy coping skills, and he did not have a healthy support system. He also had childhood trauma and was in and out of his mother's care. He admitted to not knowing how to function in the real world. Prior to his child being born, he spent 5 years in prison on several felony drug charges. And during that time, he spent 3.5 years in solitary for fighting. So when the child was removed, we completed a parent meeting and a family meeting to build a case plan and really look at the family dynamics and what they needed to heal. So due to the long history of substance use with the family, the department could not identify an appropriate relative placement, so the child was placed in a non-relative foster home. The department completed a case plan with mom and dad to include substance use assessment and treatment, drug testing, mental health assessment and treatment, parenting, education, stable, safe housing, stable employment to financially support their child, and participated in visitation with their child and attending their child's medical developmental appointments. The case plan was court ordered, and both parents agreed to work with the department on the tasks on their case plan. Mom was released from jail in 2024. This is where our community, our amazing community, comes into play. The department encouraged mom to attend an orientation at Union Gospel Mission in Coeur d'Alene. We felt this program would help to break the cycle mom was in and give her the support needed to be successful as a parent. So our Union Gospel Mission in Coeur d'Alene is a part of a larger network serving the Inland Northwest. They focus on helping individuals break free from homelessness, addiction, and abuse through a faith-based whole person approach. Mom attended this orientation and was accepted to the program. She has remained in the program through the life of the case being opened. The department made referrals to Dragonfly Support Services for our substance use assessment and treatment, and Mind Matters, which is a local therapy facility for mental health assessment and treatment. Mom engaged in all services. She completed trust-based relational intervention TBRI parenting training at UGM. Mom provided drug testing through UGM and was testing clean. She received mentorship and support in parenting and visitation with her daughter. The department attended monthly meetings to discuss mom's progress in transitioning the child to be in the program with mom. Even though mom was not employed, UGM provided the resources necessary to be reunited with her child. UGM and the department support helped mom to start to break her cycle and be healthy and be a healthy parent for her child. The child was placed back with mom at UGM on an extended home visit in August 2024. The program will continue to support mom with her sobriety and parenting. They provide housing, and as mom works through the program, they have transitional housing for the family to transition into. Mom worked hard and stayed in compliance with her program. She remained focused and dedicated in reunifying with her child. During the time of the extended home visit, mom continued to show this dedication and remains sober. She plans to stay in UGM program for the next 3 years so she can be a good sober parent to her child and completely break the family cycle. The child's father did enter inpatient substance abuse treatment after he was released from prison. He was a part of the Good Samaritan program and resided within the program. Mom and dad were learning to manage their relationship, being sober, and working on co-parenting. They had no plans on being in a relationship again, but both want to be healthy for their child. Throughout the life of this case, we have multiple court hearings. So we're writing court reports and letting the judge know what is happening in the progress. There's also a CASA worker that was involved in this case, so they're also reporting to our court system the progress. So in January of 2025, we requested, and along with CASA, for the case to be dismissed and full reunification with mom to occur. The court agreed and the case was officially dismissed. Mom had demonstrated her ability to meet her child's physical, emotional, and developmental needs while maintaining a safe, stable home free of illegal substances, maintaining her sobriety, and continue to address and manage her own mental health needs. And Dad is also on the path of recovery and learning to co-parent in a healthy way for their child. And I will pass this back over to Monty.
Next slide, please. Thank you very much, Maggie. That absolutely, this hits the bullet point at the bottom. Reunification is absolutely a success. You just heard sort of what it takes to get there. Clearly, not every home becomes a reunification success. Not every youth is going to be safe. We work with the court very closely on that. If the child won't be safe in that home, we move to, the court moves to termination of those rights. And then roughly 30 to 35% of the time, there's either those youth who can't be reunified safely in their homes or adopted or to guardianship. And really, that's what I wanted to kind of end the conversation with before we get to some Q&A, is that in Idaho, only law enforcement or judge can remove a child from their home, and that's the same on the return. It really takes a team effort to do that, and we just want to make sure those kids are safe. And if they're safe at home, reunification is amazing. If they can't be safe at home, then we look for a long-term, permanent, loving home for them as we move forward. So with that, Madam Chair, Andy, Maggie, and I'd be happy to stand for questions.
Thank you, Director, and thank you for all of your presentations today. We do have some questions. Representative Ehart, go ahead.
Hey, thank you, Madam Chair. Couple questions, and it doesn't necessarily have to be long, but let's see, I had to clear back with Addie, but again, I don't know if you guys saw that. Oh man, I'll have to go back to that question because now I think I lost it. So on the, gosh, you guys, I might, you know what, can you go to somebody else when we get that?
Coach Scott, she has a question.
Thank you, Madam Chair, and thank you, Health and Welfare and Director, for being here in the direction you're moving the agency. I have just a couple of different questions. One was on the reunification. Are you guys incentivized? I keep hearing that story over and over where they're digging up some parent out of California that just got out of jail or something like that, or some parent that's not been involved in the family forever, and it seems like there's a lot of energy being put in and going out of state, finding someone that's not been involved in his child's life and putting that child into that. Is there any kind of financial incentive that goes to reunification? And I'll just ask my second question while I've got you. The second one is, I also continue to hear that I think the law is pretty clear that if you take a child from a home, it's supposed to go with a family member, if they can find a family member. And I hear over and over family members, grandparents being denied, and they're putting them in foster homes over a family member. And I'm wondering if there's any incentives that is causing this, or is it the judges that are ordering this? Why are those two things happening? Director.
Thank you. Great question. I'd love to bring in Andy or Maggie on that. But in general, I appreciate the discussion on reunification and having a kin first culture. That is absolutely where we want to go. As you know, House Bill 245 and really encouraged and illuminated the path to having a kin first culture through rule and licensing those folks quickly. So I appreciate the questions. And Andy and or Maggie, I think Andy, we might be up for one or both of those to help us walk through those.
Yes, Madam Chair, members of the committee, there is not any financial incentive for reunification. We do have an obligation to notify both parents that their child has come into care, and to do case plans with those parents. So, but there's no fiscal incentive at all through reunification. As to your second question, we absolutely, as much as possible, want to place first with relatives. And then we look at that bigger circle around the child, around kin, who do they feel safe with? We still have to ensure that things like the person's criminal history, their home environment is safe. but we're not adding on any additional expectations. It's really about, can they meet the needs of the child, and can they pass the child protection background check, the fingerprint background check, and they don't have disqualifying crimes. And then is the home environment safe? So those are the three things that we really look at. There's no incentive not to place. There's 100% more incentive to place with relative and kin.
Follow-up. The follow-up, thank you for that answer. So when is this for unification? So if you're trying to get both parents aware of this, and you have someone that has a criminal history, but that's a parent, is that higher priority than placing him with a family member that doesn't have a criminal history? Director, whoever would like to take that.
Yep, Madam Chair, members of the committee. I think what you're asking, please clarify if I'm wrong, is there a higher priority to place with a maybe biological parent who has a criminal history than a family member who may be appropriate? We need to notice that other parent. We need to work with them to be empowered to care for their child should they choose to go down that route. But in the meantime, we can place with the family while that work's happening. So those two things can happen concurrently, and we certainly wouldn't not place with a relative who is available and willing and appropriate for that child to be with.
You asked yourself.
Thank you. This isn't my main question, but just following up on that. When it comes to a child being placed with family, does it make a difference if that family is out of state?
Director or whoever would like to take that question.
Madam Chair, members of the committee, it takes a little bit longer. We have to get court approval to place a child out of state, and we have to have some information about those checks. So we ask the other state to do those background checks, to do the home environment check, talk with the family about their ability to meet the child's needs, and that does take a little bit of time. And then we also need the judge to grant the department the ability to place the child out of state through what's called an ICPC.
Thank you. Now back to my own question. On the first thing, Ms. Blackwood, when you were talking about health and welfare going out, on 60% of the cases, health and welfare goes out to determine things. My question is, how does health and welfare do that? Do you just show up at a home unexpected? Why would I even let you in if you came to my home? I would think it'd be better not to let you in. So how just quickly does that process work?
Madam Chair, members of the committee, when we initially get the report, there's some steps that we take to prepare ourselves to go out. We operate under what is called unannounced practice guidance. So our workers can show up on the doorstep and knock on the door unannounced, but we have some specific reasons why they might do that. Some of those reasons would be if there's a concern that the parent might coach the child. Sometimes in allegations of sex abuse, the child might not, if they're having a conversation with their parent first, they might not feel free to disclose. So that might be a reason. We also do coordinate with law enforcement. So at times law enforcement may direct the department not to talk with the family first. And they take the lead. That criminal investigation takes the lead over the civil investigation that the department is doing. So those are a couple of different reasons why we might not call in advance. We do, if that list of reasons isn't in play, we do like to call families first because it's helpful in our engagement process. Folks, of course, when you're surprised by child welfare, you really might not feel like talking to us too much, and that's not helpful for anyone to understand what the circumstances of the child are and to ensure the child's safety.
Yeah, follow up. And I'm not wanting, because I'm not sure it's as applicable to what we're dealing with on the last part of this, but you had mentioned that basically it's about 11 months in foster care before reunification on the average. So just knowing, and this is something that I've learned from Representative Scott years ago, but it's my understanding the more kids are removed, 80% of the kids removed from homes for foster care or whatever, 80% probably shouldn't have been removed, and yet it's an 8 to 12 month process to get them back in their homes. That seems like a rather high rate of, well, actually, it's a pretty low batting average. Is there a way to like shut that down? Because you potentially just ruined a ton of kids' lives by removing them from their homes.
And I'd be happy to take that one. Thank you, Representative. Thank you, Madam Chair, Representative Coher. I appreciate that. I can't tell you the amount of times we've had conversations with stakeholders who want us to intervene or want the system to intervene sooner, and the same amount of stakeholders who want the system to intervene later or didn't let the process play out. So it's a really tough balancing act for the system. Clearly we demonstrated the flow with law enforcement in the courts, the checks and balances that are made available. I just really want the committee to kind of understand that there's always both sides to that. And I think that's the balancing act that the child protection system has to enter into and recognize that those interventions are not always timed perfectly depending on who you're talking to, and understand that prevents that complexity of the system that we talked about before. But I also want to commit to everyone that everyone here wants the same thing. If a child is safe, stay at home, be whole with that family. If there's some help that you need from a community member, a stakeholder, our department, we're happy to do that. But if a child's not safe at home, it is our obligation as a child protection system to make sure that kid's in a safe spot, to begin working on reunification if we can, and if not, move to permanency as quick as we can, to ensure that, as you mentioned, that reduction of trauma is in all of our best interests, certainly.
Quick follow-up.
Okay, one more.
Director Pros, I appreciate that. I know we've had another conversation, but I will say this. If a child should not have been removed from the home, somebody, I don't care if it's in the effort of safety or what, if we're finding out that even 50% is too high of a number of children being removed from the home and they shouldn't have, that trauma was created unnecessary. So I would suggest, that's a conversation personally outside of this, I'd like to continue with you guys, because those are not good numbers.
100%, Madam Chair, Representative, 100% appreciate that. I'm working myself to get out of a job. I want kids at home with their families. I think that's what the courts want. But as Andy talked about that flow chart, that's really ultimately up to the court to decide. And then we're just hey, find a safe spot for this kiddo. Love to continue the conversation for sure.
Representative Alfieri.
Thank you, Madam Chair. Director, in any organization, there are metrics that are used to determine whether you're achieving your goals. So I'm wondering, how are you measuring success? Is it just a matter of getting the family off the books and then the case is closed, or what kind of follow-up are you doing? What does it look like down the road?
Yeah, thank you very much. I have worked in juvenile justice, Madam Chair, Representative. I've worked in juvenile justice for over 20 years. I moved over to support child welfare about a year ago. And there are triple the metrics in the child welfare space that there is in the juvenile justice space. A big part of juvenile justice is recidivism, or repeat offense, and that's not dissimilar to in child welfare. You're trying to avoid unnecessary removal. You're trying to avoid unnecessary disruption of a placement. You're ultimately trying to avoid any reoccurrence of maltreatment. Certainly, time to permanency is a big goal for any child protection system. Time to termination of rights, time to permanency, time to reunification is a big one for Idaho. You don't see that in the federal metrics, but you do here in Idaho, time back to the family. So we are very data rich, absolutely, and guides a lot of what we do. One of the big ones we've done in the last year is our wildly important goal, which is the number of amazing foster parents over the amount of kids removed from their homes. The higher we can get that number, Our goal is 1.5, so that means 150 foster families for every 100 kiddos removed or needing help. That allows us to expand that service array, which allows us to place that kid more appropriately based upon their needs and their identified strengths. And so the more active foster families or resource families we can get, the better for those youth who need a short-term removal from that home for safety reasons. So not a lack of data. We've got a big data operation. As a matter of fact, our case management system is one of the best in the nation. We get phone calls all the time about how we did it. Very, very pleased to inform the committee that we're very data rich in this space.
Oh, yes, thank you, Madam Chair. So Director, how long do you follow these cases? Are they off the books in 6 months? Is it 2 years, 1 year, 10 years?
Director.
Thank you, Madam Chair, Representative. Thank you for the question. I come from a research background. I'm very data oriented myself, so I could talk about this at length. If the chair will let me, I could have the platform for quite a while. But when it comes to the sort of standard follow up, that's not as long as certainly a sort of an ad hoc or a off the shelf project might be. If you think about the amazing work being done by Project Insight, who's trying to stitch together these longer term outcomes for youth from foster care, how foster care systems interact with the juvenile justice system, how they interact with the adult correction system. There are lots of ways we can demonstrate successes of the foster care system as it interacts with other sort of system partners. So it just depends what the question is, and then what we're looking to compare.
Representative Gannon, go ahead.
Thank you, Madam Chair, and Mr. Prow and Ms. Morrison. For you, as I listen to the history of the case that Ms. Morrison told us about, it sounds to me like there were a significant number of evaluations, assessments, a significant number of personnel involved in providing information, interviews. Can you just very generally tell me roughly how many assessments or evaluations were performed? How many caseworkers actually at some point had their eyes on the file? And how many interviewers or other people and identify those people who were involved in making the very difficult decisions that you have to make?
Director or Chief, whoever's like to take that.
Madam Chair, I think that's Maggie. Are you prepared to handle that one? Thank you.
Yes, thank you. Thank you, Madam Chair and Representative Gannon. Wow. So in general, for that specific case, we had a safety assessor that worked initially with the family. And then very quickly, when we find that we have an unsafe child, we try to move cases to a case manager. That particular case only had one case manager that worked the case, who also has a supervisor. And then we have a team with our child welfare chief and our permanency supervisor that comes together, and they staff cases every 90 days to help make sure the case is moving along and we are providing the support and needed to the family. So we don't make decisions in silo. We make it as a team based on the assessments we are receiving. We typically see mental health assessments as well as substance abuse assessments. So we have different providers in the community that help with those assessments, and then they make recommendations for treatment. And so that we could have a family, and in this case, we had a mom who was working with a mental health provider as well as a substance abuse provider to help her to stay sober and to work through her mental health struggles. So they are part of that assessment. We also had a team with UGM that came along for the parenting and the mentoring. And so they did monthly, we would call them clinical meetings, where our case manager attended those meetings with mom and her supports at UGM. So they're a big part of her team. Along with the court processes, we have a CASA, which is a court-appointed special advocate, who is the voice for the child. So they were a part of these clinical team meetings and helping to make decisions for that child, especially with her being so little. It's nice for her to have an advocate. So they were a part of those, the decision makings and the assessments and giving that information to our court system. Does that answer your question?
Yeah, thank you.
Other questions? One question really quick. Who is involved in the safety plan when those are being put together?
Question. Andy, would you take that one for us?
Absolutely. Madam Chair, members of the committee, I think what I heard you say was who was involved when the safety plan is being created.
That process.
Okay, perfect. I just want to make sure I answer correctly. We use formal and informal supports around the family. We work with the parents. So if they have relatives or a pastor or a friend who can help us put together a safety plan, those are folks who would all be involved. That typically safety plans evolve over a case. We're hopeful, of course, as we work with families that the need for a safety plan or how the safety plan may look initially changes over time and the need diminishes. So those are reevaluated on a regular basis, and the department works with families around that. Sometimes law enforcement's part of that, but I would say that's probably a little bit less typical. The court may have an interest in that and want us to provide information about what the safety plan is, but it's really the parents and their supports with the department making that plan.
Any other questions, committee? Senator Beardy.
Thank you, Madam Co-Chair. And I guess this would be directed to Deputy Director Pro. That fact or that figure was thrown out there talking about metrics. About 80% of the people that are removed or the kids removed from homes are done so in error. That was thrown out. I just want to see, you never really refuted it. I just want to get some accurate statistics. That to me would seem like a pretty high number. Could you just address that?
Director.
Madam Chair, thank you. And I think that was a member of the committee with that data point. I don't think I've ever, I don't think we generated that. I don't know, maybe that's some anecdotes. I'm not sure where that came from. So I appreciate the opportunity to clarify. I'm just not in a position to be part of that. And again, that would be, a question for the court, a question for law enforcement. Certainly we're part of that. I just don't know where that came from. So I apologize.
Thank you, Deputy Director. I just want to make sure where that came from, and if we can get some accurate information or an accurate statistic, that would be interesting to have. And thank you.
All right. Thank you so much. We are probably going to have you back to our committee for some more questions and discussion, but we appreciate you all being with us today.
Thank you, Madam Chair. We want you to be proud of your child welfare system. We are proud of the things we're doing to keep kids safe. And if there's something in statute or rule that there's something in the way, let's all work together to make it work best. This is your child welfare system as well.
Thank you. Appreciate it. Okay, we're going to move on to the last one before lunch, and that is Judge Walsh, but it's from King County, who's a magistrate. If you can bring Judge Walsh up. Welcome to the committee. We appreciate you being here today. If you'll just state your name for the record and go ahead and proceed.
Thank you, Madam Chair. My name is Maylee Walsh. I'm a magistrate judge here in Kootenai County, one of 9 magistrate judges here in Kootenai County. I've been a magistrate judge over 9 years now. Our magistrate judges here in Kootenai handle all cases. So we handle criminal cases, we handle family law cases, domestic relation cases, guardianships, conservatorships, probate. It's just about everything that comes before the magistrate division. We handle that. Kootenai County has the 3rd largest number of family law filings in Idaho's 44 counties, in family law cases specifically. I've been asked to focus on the timing and the length of family law cases here today. Please feel free to interrupt me with questions. I know we're getting close to the lunch hour. Interrupt me as you see fit, please. I'll start by discussing just a typical progression of a family law case. I use the word typical. I don't use this disrespectfully. These are very important cases. These are cases of utmost importance to the courts. They involve our families. And I'll also provide some numbers relative to the number of cases processed by the courts as well. In context of child custody, the court sees generally 3 types of cases before it, again, relating to child custody, specifically initial paternity or custody actions involving unmarried parents, divorce proceedings, which include a custody action, and then a child custody modification action. So parties coming before the court seeking to modify a previous order relating to custody. These cases start with one parent filing a petition in front of the court, and then there is a response. I conferred with my clerk just to confirm the timing here, and we did a bit of an audit of my cases. Madam Clerk will set a scheduling conference when there's a response to an initial petition. Madam Clerk will set a scheduling conference within 4 to 6 weeks. In that intervening period of time, I issue an order of mediation, and that mediation order simply informs the parents that they need to mediate the case before trial. There's another order that relates to attending the Focus on the Children workshop, or Focus on the Child workshop. And I'll talk about that here in just a moment. I'll talk a bit more about mediation and the focus class here in just a moment. At the scheduling conference, so the scheduling conference is really the first opportunity that the parents have to be in court and talk with the judge. As magistrate judges, we deal a lot with people who represent themselves. And so it is their first opportunity to be in front of the court. And being in court is extremely stressful for people, stressful for members of the community. At that scheduling conference, I endeavor to talk with the parties about the steps they've taken. So Focus on the Children class, whether they've contacted a mediator, whether they've had an opportunity to talk about resolving their cases, talk about the next steps, go over the rules in terms of disclosure. We also discuss whether the matter needs to be set for trial. Or we need to have another status hearing. A lot of times parents come into court who are representing themselves and they are confident that they can come up with a resolution. They just need a little bit more time. And so I'll set the matter for another status hearing. I seek input from the parents in terms of timing, what works for you, a couple of weeks, a month, what do you need to have good, fruitful discussions about a parenting plan, and then bring the family back to talk about whether they've been able to strike a resolution, or do we need to set this for trial? In going through this audit, we're generally setting trials about 3 months from the scheduling conference. For a lot of families, that's too soon. They need more time to put together the information that they would like to present to the court. And that also is dependent on the length of time trial is needed. If the parties need a lot of time, like a week for trial, it might not be in 3 months because we have to find a week to set that for trial. But we do try to endeavor to set that very quickly. Before the trial, we have a pre-trial conference. And again, we just check in with the family to see if there's any way we can resolve the case, if there's any additional outstanding discovery, discuss the scheduling order, and talk with the family about trial, what that looks like. I want to back up a little bit and talk about the focus class, because it's a bit unique in Kootenai County that we do the focus class in person. And judges participate in the focus class. And it's a really amazing opportunity for the judges to interface with people going through the family law process, going through divorce and custody actions, and get to have a judge talk to them about the process. All of us magistrate judges rotate. There 9 of us do the class and present at the beginning of the class and give our perspective from the bench. And what we try to empower the parents to do is to come up with a parenting plan that is consistent with their children's best interest. And that statute is preeminent here, 32717. And I know it's been discussed previously in terms of what is in the best interest of the children and how judges make decisions as to what is in the best interest of the child or children. And so we, as judges, encourage families to make their own decisions on what parenting plan is. But that's hard. These individuals are often in relationships that are newly fractured, going through divorce, separation. And so they need additional tools. Well, what does a good parenting plan look like for a 2-year-old? What does a good parenting plan look like for a 14-year-old? Where can I get resources to understand what that looks like moving forward? And the focus on the child workshop does just that. It presents to the parents an opportunity and resources to find out where to go to get that information. And I talk with them and try to empower them to come up with those decisions on their own. Because there's this presumption that both parents are fit and proper parents to come up with a parenting plan. And I see the court's obligation as providing a forum for them to make those important decisions for their family. Now, when all else fails, and I have to be the final arbiter of which of these 2 parenting plans are in the best interest of the child, I'm prepared to do that at trial. But the decisions that I make at trial are never as good as the decisions that parents can make on their own. And again, the purpose of talking with them at the focus class is to let them know that trial and being in court is expensive, it's time consuming, and allow them or provide them information on resources that they can gather to make those decisions on their own. Would note that the focus class is $20 to attend, and they can also have that fee waived if they are not able to afford it.
A question for you, Representative Scott, Chair Scott.
Thank you, and thank you, Judge, for being here. I had no idea it was this complicated, that you were spending so much of your time, it seems like, in a counseling role for fighting parents, maybe. And so I guess what I'm wondering is, from your perspective as being a judge, I mean, you feel like this, like the family, a lot of this is counseling on your part, and if so, does there need to be another step before it gets to your courtroom? Because we get all the complaints that there's like really bad judgments being done. But you're being put into a really awkward position because you're counseling. Sounds like you're helping them with all the mediation, warning them, hey, court's going to be really bad, so hard, and my decision's final. Is there some step we're missing that needs to be, these families need to go through? Just in your experience.
Madam Chair, thank you. And I've thought a lot about this as well, because court and being in court is so stressful. And if they can resolve this before coming into court somehow, wouldn't that be best for these families? That said, I think that there is some power in having someone mediate these disagreements. And I regularly have families before me who are going through significant issues, substance abuse, mental health issues, and they are able to successfully together come up with a good parenting plan. And sometimes I have to involve myself, not just as a counselor, but someone who has a tremendous amount of experience in the family law arena, what works for families, what tends not to work for families in similar situations, and bring that to bear in talking with the parties and empowering them to make decisions based on information that I provide them. For example, this has worked in this context previously. Do you feel comfortable doing that? Having supervised visits for a little while? Are you comfortable with having visits at grandma's house? So really proposing solutions to these problems. And so I think bringing the parties together in court can be very meaningful at striking resolution, and also can help the parties later develop what I call the co-parenting muscle, which is coming up with agreements together, starting those steps to co-parenting in difficult circumstances.
Okay, Senator Recti.
Thank you. Your Honor, I was hoping you could share with us the number of cases that you have on your docket, and then just, I don't know if you have a way of breaking them down so that we understand the varied nature of those cases.
Madam Chair, Senator Recti, just for clarification, do you mean just my family law cases or my cases generally?
Your cases generally, but then I was hoping you could give us a sense for how many of those are, family law, or however you break those out?
Madam Chair, Senator Ruckty, I would say that roughly right now there's a even split between my criminal cases and my civil cases, and then shortening that up a bit with my family law cases. They take generally, so I have a week of civil trials every 9-week or 8-week rotation. I have a week of civil trials for purposes of family law trials, but other civil matters as well. And I'm not sure I answered your question with that.
Yeah, just to follow up. Thank you, Madam Chair, and then Your Honor. Well, I was hoping you could tell us how many cases you have, just so we have an understanding of what a typical, magistrate judge has on their docket to handle.
Thank you. In looking at some recent numbers, open pending cases before me, just family law cases, I have 48 open pending family law cases, and that means that they are past the initial filings and either at the scheduling conference or headed to trial.
Does that answer your question, Senator?
It does. Just one more follow-up, Madam Chair.
Yeah, go right ahead.
Madam Chair, Your Honor. So one of the things that I've heard, and I have a lot of sympathy and empathy for people who are struggling with this, but they talk about how expensive litigation can be. And I've heard people mention how many motions get filed. And, if you're the parent who feels like you're kind of being run through the ringer, and you've got a spouse that maybe has assets and you don't, they've got a good attorney and maybe you're struggling just to hire one. The system can probably feel like it's not working in your favor. Can you help us understand, give us some insights as to whether you see that happen and what can be done about it, if anything?
Judge Walsh.
Thank you, Madam Chair. Senator Ruckty, that's a really good question. This imbalance between people who are representing themselves and someone who may have an attorney representing them. I think that the Supreme Court has done a good job of changing the rules a bit, and this happened back in 2015 with the family law rules, to create a more even playing field in terms of the application of the rules of evidence and attempts to reduce cost. So we now have means by which the court can have informal custody trials, which are very straightforward. They don't follow the normal question-answer process and admission of exhibits, which puts the pro se litigant sometimes at a disadvantage. They don't know all the mechanics of introducing evidence. And also, we've been empowered recently to engage in judicial settlement conferences, which another huge cost-saving means where the judge attempts to reach settlement between the parties, whether they're represented or not. And so the judge will seek consent. This is completely voluntary with the parties, and try to strike agreement. And that does impact the power imbalance, if that answered your question.
Thank you.
Representative Ehart.
Thank you, Madam Chair and Judge. Thank you so much. These things help. So this is a little more rhetorical, but just when it comes to mediation, I've had some conversations. We know that Boise State, actually has a mediation program, but two parents divorcing could actually request anyone to be a mediator, correct? Like they could use their pastor if they wanted to, correct?
As well. Madam Chair, Senator Ehart, absolutely. Absolutely. They can use, again, we just provide the forum to empower decision-making. And I think it's important that parents use whatever resources they have available to come up with good parenting plans, because those are the ones that last and work, the ones they come up with together.
Awesome. And then follow up. So as you were kind of talking about the parents and setting them up visits, maybe trying to find a means that work. But so my question is, what has to happen? What rises to the stage that you, and I don't mean like you personally, but that a judge, what has to happen though in your mind that you would remove a parent's ability to see their children on a basis that is productive for that parent? Like, what has to happen?
Madam Chair, Senator, Representative Ehart, the right to parent is fundamental. It's enshrined in the Constitution. And so to absolutely remove a parent from a child's life requires a high burden, that this is not a safe parent because of substance abuse issues, mental health issues, or incarceration. And so that is a high threshold to meet. As a magistrate judge here in Kootenai, we also do child protection cases. And mindful of what it means to remove a child from its environment and from its circumstances.
So follow up. So there are a couple things that we ask you, and we appreciate your addressing this, though, that seem to be at the heart of things we're hearing. And granted, we understand, we really do, that when we hear things, we're hearing it from that paradigm of the person that maybe doesn't like the ruling. I get that. However, we're also taught to, where there's a lot of smoke, there may be fire. And one of the things that, including people I know, that's a little bit frustrating is also this idea that the child is basically being removed from what I would consider at least 50-50 custody from a good parent, okay, and really has had their opportunity to visit with them slimmed down. If that happens, this is part of what we're also trying to decide, recognizing some of it's not all, but let's say it's true. What are the recourses? Because we had already heard from the gentleman before that, they can't decide on, when it comes to, these committees, they can't decide on judgment from the judge, has to be ethical. And so this is a part, that feels pretty heavy. And I know you feel the heaviness of this on a weekly basis. What are the recourses if truly something like that really has happened? Let's say it really has happened.
Judge. Madam Chair, Representative Ehart, it does happen. And we've heard that here today, where there may be false allegations of abuse, parents who withhold children from the other parent. And I regularly admonish litigants in my courtroom, if it comes to pass that these allegations are not true, that these the withholding of the child is without cause, then there are ramifications. And that can be a modification of custody. That can be a change in the custody order. I truly believe that the adversarial process, the process that we have now in presenting evidence, is the best way to get to the truth. And so having these competing interests come into court, and obviously trial, what you're describing, Representative Ehart, is really sort of the far end of the spectrum, because most cases settle, right? Over the majority of cases end up in agreement and settlement. Very few cases end up actually going to trial because the parties come to resolution or agreement. I think right now in Kootenai County, it's roughly 19% of cases that actually go to trial, and that includes child support trials. I mean, that includes all family law trials. And so very small number. But one of the factors, the 32717 factors that the court considers, is the character and circumstances of the parties involved. So their behavior and their conduct, especially when the court is watching, when the case is pending, and their behavior during the pendency of the proceedings is going to play a role in the evidence received by the court and the decision the court will make.
Well, yeah. So just a little more clarification, Your Honor. I appreciate that part of it, but what happens if, for whatever reason, because we're all human, I'm the judge, I'm having a bad day. Maybe, I don't know, today I don't like men or today I don't like women. I mean, for whatever reason, I make a bad decision. And it is wrong. And I'm removing the ability of one of the parents when they haven't done anything wrong. That's what I'm asking. What is the recourse, if any? And maybe you gave it to me and I just missed it. What's the recourse where a judge does something? Are there any recourses?
Madam Chair, Senator, Representative Ehart, I'm
Oh,
sorry. I misunderstood your question. I apologize.
No, you're fine.
Yes, absolutely. There is recourse. If a judge makes a decision that one party or both parties feels is not appropriate, they have several mechanisms to address. They can reach out, request a motion to reconsider in front of that judge. So Representative Ehart, your description, the judge was maybe just having a bad day. Or
I'm giving them the benefit of the doubt.
They have motions to reconsider. They have the appellate process to appeal in front of the district court judge. So the cases that are appealed in my courtroom go to the district court. And there's review in that capacity. More long-term, so stepping back a bit, I'm part of the mentor judge program. And what that means is I sit in court and watch new judges perform at trial, after trial, during contested litigation, and provide feedback. Along with that is what's called a judicial performance evaluation that I review with that sitting judge to discuss issues that they may be facing on the bench. And so a means of mentorship for newer judges. Also, judges periodically do have surveys that are released to the community that go to individuals in the community that they're able to respond, but also the bar and court personnel that can respond to those surveys. And I'll tell you, the judges take very seriously the feedback because we don't get a lot of it. Take very seriously that feedback. And as a mentor judge, I review that feedback and make regular contact with my mentee judges about the nature of that feedback and in fact their progress over time. And then ultimately as well, we have judicial counsel, and as I understand it, Judge Brody may have talked with you guys a bit about that process.
Representative Scott.
Thank you, Judge. We just get so many complaints from citizens. I think a lot of the reason this task force was started is because of parental rights, and where one parent's given a child and another's not, and a lot of the complaints, there's a couple different major complaints we get, but one of the big things is that one of the parents has criminal record, is a pedophile, and they're getting the custody over the other parent. And you mentioned the character and circumstances that the judge witnesses, and I have to imagine, I'm not a parent, but if I was a parent and my pedophile ex-husband had my child, I would probably, not very emotional person, but I'd probably be maybe not behaving great in the court because I was so frustrated. But I'm wondering, are you bound as a judge, or are all judges bound to look at every piece of evidence? We hear over and over again that the judge won't take my evidence. They won't look at my evidence. I've got letters from children saying the judge won't, it's unbelievable the amount of evidence that's been sent to me, and in the same story, the judge refuses to listen to it. Are you bound as a judge to have to take in all evidence? I mean, I don't know. Is that something you have to do?
Judge Wells.
Madam Chair, evidence comes into court in a multitude of different ways. If there is a formal trial, there are rules of evidence that apply in terms of admission of evidence. And so that some evidence may be disregarded or not considered by the court is because I'm bound by the rules to consider or not consider that evidence. Once that evidence is admitted, I do and must consider it. The informal custody trial is not bound by those same constraints, if the parties agree to the informal custody trial, they can literally just give me a binder. Hey, judge, this is for you to look at. And of course I say, hey, can we walk through these things together? And can you explain to me what these things mean as we walk through them so I can understand their position? It is a real difficulty when these cases go to trial and they are high conflict cases and you have two parents who have very different, sometimes diametrically opposed parenting plans. The court has to pick between one of two. And these are difficult cases with a lot of emotion. And they're sealed cases. So it's difficult to know. I think someone, an individual earlier said there's another side to the story, and that often is the case. That said, in terms of the testimony of a child, when it's appropriate, and by that I mean age, and a lot of other circumstances, I have no problem, and I know many of my colleagues have no problem with doing what's called an in-camera interview of the child. And that's when you bring the child into court. They're not alone with you, obviously. Madam Clerk, you're recording the proceedings, and you talk with the child, and I have done that many, many, many times. It is amazing to me to learn what I learned from these children in talking with them. But I do require that if we are going to have an in-camera interview with a child, that the proceedings be sealed. That neither parent can access the recording for any other reason except for fraud or abuse or some other situations. And the reason for that is because the child needs to feel free to disclose what they need to disclose without fear of pressure or punishment. I always ask the child, what can I say? Is there anything I can tell your parents? What can I disclose to your parents about our conversation today? And they'll tell me some things or nothing, or very touching things that they want their parents to know. Most of the time, uniformly, the children will say, I want mom and dad to stop fighting. I don't want to come to court. But I do feel as though those in-camera interviews are very empowering for children to come into court and talk with the judge. Now, of course, maturity is an issue. I mean, bringing in a 5-year-old, it's probably not appropriate. Bringing in a child that may be subject to really immense pressure by one parent or both, maybe not appropriate, because I have had situations where it's almost scripted, their conversation with me, and I just had to end the interview. Was just too stressful for the child. But I do find that those are useful tools, and I do engage them, and I use them in my decision making.
On that note, can a child have an attorney present with them during those in-camera interviews?
Madam Chair, yes. Yes, if that, or a guardian ad litem. I try to accommodate as much as possible. If they want to bring their dog in because it's a comfort for them. If they want to bring their sibling, I've had siblings come in simultaneously because they just supported each other and wanted to be there together. I will do that. Family court is a bit messy, and we have to be willing to, and I mean that with all due respect, a bit messy. I just mean you can't follow a regimented script because these are individuals with very unique issues, and they need individual attention and care and regard in helping them make decisions. And ultimately, we end up having to have a contested trial, making them feel heard.
Senator Ruckty, go ahead.
Thank you, Madam Chair. Well, this is more of a comment. I've tried a lot of cases, and I know that clients, when they get in the courtroom, it is stressful, and they're often surprised. So, in other words, when we're getting ready for trial, they want to be able to say their piece, and they are looking forward to it. And then you get into the courtroom, and they start hearing things from the other side, either from a witness or from the lawyer, refuting what they believe is true. And it's really hurtful to them. And they'll say, they'll whisper to me, or when we take a break, they'll say, well, how can they say that? And I have to say, look, the courtroom is for each side to be able to tell their version of what happened and how it happened. And so you're going to hear this stuff. It's going to hurt because you don't like it, but it doesn't mean they don't have a right to say it. So I think that's often what happens. I think clients also, they confuse opinion with fact. You can bring opinions into a courtroom, but it's through experts. Other than that, the only people who testify are there to testify about facts, and the rules of evidence are designed to make sure that only reliable facts are presented to the court. And that can be frustrating and misunderstood by people who don't deal with the court system very often. It feels unfair to them, and I understand why. But when you really, when you dig into it, you realize why you have to have these rules of evidence and why it's important. But I think oftentimes that's where people who aren't in court every day or frequently, they get frustrated with it and feel like it's not fair. But it's the way the system works, and it really does work well to get just the truth out.
Well, Madam Chair, I agree, and that's one of the things I talk about in the focus class is trial is the Super Bowl for lawyers, and judges like trial, but it's not great for the litigants. They hear things that can't be unsaid, can't be unheard about their parenting ability, and it's really advocacy. It's not necessarily grounded in this is how the person truly feels about the other person's parenting, but it's one lawyer conveying thoughts, trying to win their case. And so hurtful things are said in trial. And again, they retain so much more control staying out of trial.
Representative Gannon, go ahead.
Thank you, Madam Chair and Judge. One thing I've heard several times now in these proceedings is that that a child is placed with a pedophile parent. And so my first question for you is whether you are aware in the system of children of any case where a child was placed with a parent who was a convicted sex offender pedophile.
False. Madam Clerk, Representative or Senator Gannon, I am not aware personally of a circumstance like that.
Follow up.
Thank you, Madam Chair, and thank you, Judge, and Madam Chair. So I guess just as a comment, I am very concerned about that kind of factual possibility or allegation. I mean, if that's happening, I want to know about it. And so if there is some evidence that somehow a child is being placed with a convicted pedophile over the other parent, I would hope that someone would come to the committee with a court order or some kind of documents documenting that kind of situation, because I'm very concerned if that is happening. And I want to know about it, and I want to know what we can do about it. But so far, I haven't seen the hard evidence that has happened. And so I look forward to hearing more. Thank you.
Thank you, Representative Gannon. Well, we noted that, so thank you. Senator Carlson.
Thank you, Chairman, and Judge Walsh. You seem to be very thorough, and you seem to take great care in dealing with these types of cases. How do you deal with, maybe not all judges in this space put as much care into it as you do? Do you have any suggestions for us on what we could do to make it more a better system? And in addition, I've been made aware that there's counties, which I think you may be one of the judges that does this, where the magistrate has to deal with civil and criminal and family court. And so they may not have as much experience in family court issues. So I'm just trying to wonder if you have any suggestions for us on how we try to figure out the solutions.
Madam Chair, Senator Carlson, that's a great question. Would require a very long answer, but I will say this. I feel extraordinarily fortunate to be a magistrate judge here in Kootenai County, in that I handle all kinds of cases. Ultimately, I believe that that makes me a stronger judge for the family law arena, in the sense that I really understand what's happening in the community, because one week I'll be in the child protection realm dealing with shelter care proceedings, what we're seeing here with parents who are truly unable to care for their children because of a mental illness or incarceration or substance abuse, significant, severe substance abuse. And I can go from that world to the criminal world, where I see what impact substance abuse has on families. And then I can pivot to the family law arena and be dealing with those same communities. And in Kootenai County, getting to do that has been, I think, very fruitful and meaningful for me on the bench. And I appreciate that we have maintained that system of having judges of essentially general jurisdiction that handle everything. Do I think that we can do things better? Yes. And I'm always open to suggestion on how we can do things better as judges. Try to regularly, and for me personally, we put on a law day with the pro bono clinic. We did that here this year. This is the second year in a row we've done that, where we've invited lawyers from the community to, at no cost to community members, regardless of income, come in and address their family law cases, wills, and trusts. Again, because I think access to justice also means having access to good qualified counsel to advocate on people's behalf. And so a bit of a roundabout way to, I guess, answer a very long, the answer will be very long. But yes, I do think we can do things better. I as part of the Mentor Judge program, I do talk with judges, newer judges, about training opportunities to ensure that some of the newer judges are also able to access as much training as possible as it relates to family law cases, criminal cases, and other contested proceedings. And I know the Supreme Court does a very good job of providing resources for new judges as well, to get them to have some additional experience in areas they may not otherwise be wholly familiar. Senator, did that answer your question?
Yeah, Judge, not really, but it did help on some level, yes. But I just feel like we have a big challenge in front of us, and we obviously have some issues. And I want to commend you for what it seems like the job you are doing. Thank you.
Thank you, Senator. Representative Ehart.
Thank you. Madam Chairman and Your Honor, we could probably schedule, I so enjoyed you, and I feel like I could probably schedule a whole meeting with just you. But here's another question for you, that it's not just the time that comes up, but financially, as I've said, I keep saying it, divorce court's big business. I firmly believe that. Whether it's motions to delay, proceed, whatever. And I had it doesn't matter who, but I had one of the legal people within the profession with whom we're working tell me, well, we have things in place for those who don't have money. And I said, that's missing the point, because people start out with money, and by the time they're done, they have no money. And so, and they can't, keep fighting. So my question was, we've been looking at the surveys or different things that are coming in. Various judges request various studies and make, the litigants, the parents, go and get certain studies. A friend of mine, had to get a most unique study that I haven't heard anybody else get it. Like, what the heck? What studies what studies do you require, and what relevance if you require the study, I'm assuming you're going to use it, and you're not just, making somebody spend their money. What studies would you say in your experience are most important to require? And, I guess for me, I would just like to make it a law that we've got to get rid of some of these studies. Anyway, I'm pontificating. Can you expand on that as well?
Madam Chair, Representative Ehart, no studies. I require no studies. And by that I mean, if the parties come before me asking for studies, if they're asking me for a brief focused assessment or a parenting time evaluation or a parenting time coordinator, if both parties are asking for it, I'll order it if they're both asking for it. If one side is asking for it and the other side is saying no, well, the party asking for it is going to have to demonstrate that it's necessary, that there's good reason to get this study done. We still live in a rural community. Those studies are, trying to temper my word, I'll say outrageously expensive. They're outrageously expensive, thousands and thousands and thousands of dollars. And I'm not going to put that on the people, the parents who are in front of me. And frankly, they don't always give me all the information that I need. And so I don't require any studies. Now, if you have a parent in front of you that is mentally ill and unable to parent, struggling with substance abuse, that parent may want to undertake an evaluation and go through treatment recommendations so that they can demonstrate that they're a safe parent. That parent may want to enter into counseling, domestic violence counseling. And of course, this is assuming that we don't have the far end of the spectrum cases where we have domestic violence, right? We just do not have a safe parent at this point. And so I am very careful about what I order in these cases, because these are families that can't afford these things. And it's also, it slams the courtroom door shut for them. Because if they're not getting these studies and then the judge is saying, well, where are my studies? And they're saying, well, we can't afford it. That might delay the proceedings. And so really it has to be demonstrated. And I think the rule itself requires that the study has to be related to an issue involved in the case. So it just can't be, well, one time, this person may have behaved a certain way 25 years ago, and so they need to get a mental health evaluation. It has to be related to what's the controversy before the court, and good cause has to be shown that it's necessary. And so there are quite a few barriers to requiring that parties undergo studies. Now, when you have high conflict situations, judges may need additional information. When you have children who are making allegations against one parent or both, that child may need a guardian ad litem to represent their interests in court. You might want just a neutral third-party observer in the home to see what's going on. If one parent is saying, well, this child's always fearful during exchanges, and the other parent is saying, that just doesn't ever happen. And so, but again, I'm greatly informed by what the parents ask me to do. Again, as I said at the outset, I think that court is really, or should be, a forum to protect the decision-making process. And if there needs to be trial, happy to make the final decision amongst competing interests and applying the law.
One follow-up. Okay. Wow, thank you. So it's kind of a combined follow-up then, because to your knowledge, are there other judges like you that don't require studies? And then my other question would be, kind of diverse, but in your court, if one of the parties is trying to use a motion based on criminal activity, his son's coming up and they were accusing him of abuse or sexual abuse, would those, in your mind, best be referred to the criminal court, or do you try to handle that?
Madam Chair, Representative Ehart, just to make sure I understand the questions correctly. So do I refer an allegation of abuse to the criminal court?
If it's criminal activity.
I mean, I may. I think in the family law context, the rule requires, and I know there had been some discussion about this previously with our good sheriff, and that is, does the court have an obligation to report allegations of abuse? Absolutely. All judges are bound by the same rule. If we hear that there's abuse, or we see a petition alleging abuse, or someone in court says that there's abuse, we absolutely are required as mandatory reporters to refer that case or refer the matter to the Department of Health and Welfare. And we do that regularly. I would also let the committee know every magistrate judge is on call 24 hours a day, 365 days a week, for calls for warrants, for orders of removal and shelter hearings, so search warrants, arrest warrants, etc., 24 hours a day. And so while the Constitution may not permit the arrest of a misdemeanant without being in the presence of the officer or a citizen's arrest occurring, the police officer can get on the phone, call the judge, ask for a warrant. Anytime.
Senator Bierke.
Thank you, Madam Co-Chair. Judge Walsh, nice to have you here today. We're in an interesting position. We've got, this is 2 of 5 this task force is going to take on. We've heard a lot of testimony already to this point. As a representative of this, state, we are here to represent, but we also represent the system that ultimately represents the people we represent. So we have a dual capacity here. We want to make sure the system works. And we also want to make sure we represent our constituents. So it's a difficult charge. My question is reflected. It's like it's just an age-old story, right? There's a Bible verse talking about making reconciliation with your opponent of law on the way to court, unless you basically losing every bit of money you've ever had, right? So we've been down this road before. How much do you feel? Like I said, I've got a buddy that went through 7 years of a divorce, and the final conclusion was exactly what his wife and he sat down at a restaurant before they decided to go to court. Exactly, except they were a lot less wealthy. And how much effort should we be putting, in a way of maybe getting rid of your job, like Deputy Director Pro said, you don't want to put yourself out of business, to channeling these, these people in this very vulnerable position away from the judicial system and process. I think, how do you feel we are doing in that regard as a state to ensure that we can fix the problem before it becomes an even bigger one?
Madam Chair, Senator Bierke, great question. I think we're doing a pretty good job in the sense that we order mediation that's outside of the judicial system. And stepping back just a moment, when a person files a custody action or divorce, they're coming to the court asking for intervention. Nothing is prohibiting individuals from not coming to court and making agreement. And so they've come to the court seeking redress. They want help. And so some of the means by which we offer assistance before they come into the system, and as pointed out by Senator Ruckty, have a trial where ugly truths are revealed, and it's very uncomfortable and very expensive, and you get to the same place at the end as you were in the beginning, except for a lot more money, is by directing the parties to things, as I discussed earlier, the focus class, empowering them to make decisions on their own. It's $20, and it comes with a tremendous amount of resources. I mean, Family Court Services does such a fantastic job in Kootenai County of assisting families. Free advice, helping them file, come up with parenting plans, directing them towards resources, paying for classes, solution-based co-parenting classes. So you have all of that happening. And then we also are so fortunate in this area to have fantastic mediators, and just really wonderful mediators who care greatly about families in this community. And over 70% of cases that enter into mediation are resolved in mediation, and that happens completely outside of my presence. Now, I say that, but those individuals sometimes will come back to court and they'll say, Judge, we went to mediation but we're not sure what to do next. And then I have Madam Clerk print out the forms, because there are forms that the Supreme Court has made available online for judgments, for modifications of custody judgments. I print them out. We talk about it, hand the paper out, and get it done right there in court. That's happened just last week. That happened last week where I had parties in court and we just passed paper around and got it resolved in court without having them come back or involve attorneys. They did it through the mediators, but they just couldn't get past what paperwork I need to file next. And so I do think that our system does a good job of supporting individuals making decisions outside of the court system, and then providing supports for them to get into the court system to get their paperwork finalized. I think we do a good job of that.
Just want to comment. I'm hoping that what we end up dealing with, when it's all said and done, is a couple of one-off situations. I certainly don't want a trial situation to, it be enacted here in Idaho, where we're putting our judicial system on trial without some real accurate information as to what's truly going on. And if you have anything that we can talk about in the future that we can kind of avoid this in the future, that would be ideal, I think, for the state and for all of us.
As well as you have a comment to that.
Madam Chair, Senator, I think I invite you to come to court. Not that long ago, I invited a commissioner to come into court. He had some questions about what happens in juvenile court and some concerns that he had about juvenile court. I think that the courts absolutely should be transparent. That transparency is pivotal to public trust. I invite you to come to court, would encourage you to come to court. You can reach out to my clerk, my judicial clerk, and we can let you know a good time to come in and just watch. When this individual came in to watch juvenile court, he was surprised with the types of cases that are handled, the judge's role in those cases, the solutions proposed in those juvenile cases, and I think it was very informative. And our courtrooms are open to the public, obviously with some exceptions, child protection. We heard a little bit about that earlier. But even in the juvenile case, there were some of those cases that were sealed cases because children's mental health was involved. I had talked to the parties beforehand, so the lawyers and the litigants, and asked if it would be okay for someone from the commissioner's office to sit down and watch the proceedings. They agreed that it would be fine. They consented to it on the record, and he was able to sit through the closed proceedings as well. And so all that to say, would love to have you in my courtroom anytime so that you can see what is happening in your courtrooms and how the system handles some higher conflict cases and what people's general experience is. Thank you.
Judge, we really appreciate you being here today. Do you have any parting words to leave us before we leave?
No, thank you very much for your time, Madam Chair, committee members. Please feel free to reach out to me. If you have questions for me, I'm available. And thank you for accommodating my time request as well. I'm also the mental health court judge, so I had to be in court this morning. So appreciate that you accommodated my request to speak later.
No problem at all. We'll probably have some follow-up questions for you that we'll go to.
Thank you very much.
Committee, we are going to go ahead and split the break for lunch. We'll be back here at lunch. So that should allow everybody a little bit of a breathe, so we'll go ahead and get the next. And we have one more presenter that is here with us today, Conrad Wells. And he's here to talk about forensic trauma and abuse and what their organization does. And so we know we'll have other people circling in. After he gets done with this presentation, I'm going to be turning over the gavel to my co-chair, Representative Scott, and she's going to be conducting the public testimony portion of things. So she'll have a few words to say before we start that, and then we'll proceed with that portion of our meeting today. Yeah, we can keep putting them in. So, Mr. Woodall, thank you for being here. Go ahead and introduce yourself for the record and then go ahead.
Thank you, Madam Chair. So my name is Conrad Woodall. I'm a former police officer and college professor. I have about 25 years working with sexual assault trauma survivors. Many of those survivors had childhood trauma histories, and I have a master's degree in forensic psychology. My current position, I serve as the Director of Operations for Cleveland Hospital, which is a K-12 charter school here in Post Falls. Some of my job duties there, I head up our suicide prevention team. I run our behavioral threat assessment team, which is where we're looking at serious threats, kiddos that might, be a potential active shooter type situation. I handle our child custody cases, pretty much any of the things that have to do with potential trauma, abuse, situations like that going on in the school, I deal with. So I had some comments, and I've kind of adjusted them as I've listened to the testimony that was taking place this morning. And the first thing I wanted to address was Representative Earhart's bill, which she's not in here right now, but I can speak from personal experience. My wife actually is, she's on break now, waiting for back surgery, but she is a forensic nurse at Kootenai. And the law that Representative Earhart wrote, it's not being utilized correctly, and we heard that today with Scott. And I can tell you that their policy for my wife's parenting team is also the same. They don't, if there's no parental consent, they will yank. And if you read that bill, which I would urge anybody, if you're still here with those organizations, I want you to read the bill. It defines healthcare service. And it says, means a service for diagnosis, screening, examination, prevention, treatment, cure, care, or relief of any physical or mental health condition, illness, injury, defect, or disease. A forensic exam is for the purposes of collecting criminal evidence. It is not treatment. So there's no reason for these organizations to not be conducting forensic exams based off this bill. What you get is people in risk management that read something, they get all scary, and then they don't do what they should be doing. So if you're listening, get a spine and start doing these bills. Now, there's a second part of this bill that says, no healthcare provider or government entity shall deny a minor child's parent access to health information. In other words, if they have health information in their control, you can't deny it to the parent. There's an exception here. If the parent is subject of an investigation related to a crime committed against the child, and the law enforcement officer requests that the information not be released to the parent. Here's the question. How do you get information of a crime if you can't do a forensic evaluation? Meaning the hospital wouldn't even have possession of the information if they need consent to get the information in the first place. Does that make sense? So this bill, as it's written, should be no problem with forensic exams. But like I said, I can tell you that it is the policy right now to not do forensic exams because they're scared of this, which they shouldn't be. So hopefully we're going to fix that. I don't feel there's a need to, but you got to do what you got to do. Here's what I would also hope is that it breaks my heart to think that in between now and the next legislative session, we might have a case where they don't do an investigation. So might I suggest maybe that we try to get an AG ruling on that one point on this legislation in between now and then. So we possibly just coast with it until we get the next legislation going. So another issue that I want to talk about with the judge, this is the first time I have kids in my office all the time talking about child custody. So they won't want to go to this parent's house or that parent house, a very common thing. I've also had parents in my office dealing with custody issues related to schools. And this is the first time I've ever heard that there is an actual process for the child's voice to be heard. I've never heard that before. I have heard parents and kids complaining that they do not get to speak in court related to this. Now, here's something that is problematic with that. This is typically internet. There's no set age, but internationally and across the nation, we typically count the age for mens rea as 14. What that means is that you can be held criminally liable at the age of 14. Okay. In Idaho, there's the code. I have it here. It's 20-509 that details that children ages 14 to 17 can be tried as adults. So if we're talking about a criminal behavior, we will try these kids as adults when they're 14. But when we talk about family court, we won't let them speak as to which house they're going to be more comfortable in, or which house is less abusive. There's also another code in Idaho, 20-509, that details that a minor, 14 and above, can check themselves in for mental health treatment. That was in response to the rising suicide rates of this generation. I think it's good. But you don't need parental consent, because we recognize that a minor, 14, 15, 16, 17 years old, can describe their emotional state and their suicidal ideation to the point of checking themselves into a mental institution. Now, after they get in, you got to call the parents, but they don't need parental consent to check in. So why is it that we're not allowing these kids to speak in court? And like I said, I have, this is the first time I've ever heard of a process, and I don't know if that's just happening in the prior judges court or not, but maybe there's something legislatively that we can look at, because we've carved out other sections, right, for trying a child as an adult. We've carved out a section for an adult being able to check themselves into a mental facility. Well, maybe we got to carve out a section that allows the child to have some type of right of speech in family court. I'm going to read for you, so I don't forget some of the facts, a case that we had, and it'll tie into another issue. At our school this past year, we had a case involving molestation allegations against an ex-husband. Two girls who had reached adulthood and no longer lived with either parent both came forward with allegations of molestation. It is common for molested children to start reporting after they have exited the stage of development where molestation carries fear and peer embarrassment and rejection. This is stage 5 of Erickson's. In this case, a minor child was still at risk, which was the motivating factor for the older sisters to finally file charges. I was astonished to find out, and I just verified this with our sheriff back here, that Idaho has no process in place for police to serve an emergency protective order at the time of arrest. As a former officer myself, I've served many emergency protective orders in my career, as the sheriff did in his prior term in California. The mother was in my office the day after the arrest, completely distraught that the suspect might come in and sign the minor out because they shared custody. She didn't know what he would do or what he was capable of. Considering the fact that in 2023, the National Center for Missing and Exploiting Kids reported 59% of all Amber Alerts were family abduction cases, I can see why she was terrified. Before she could even begin to file the restraining order, he had already bailed out. Then, because she was unfamiliar with the process and did not articulate the situation well, the court denied her protection order, even though detectives who conducted the interviews determined probable cause for an arrest. This is why other states have officers fill these orders out based on the probable cause they used for the arrest. The suspect is then served during the booking process, and a hearing is typically set within 5 to 7 days to determine whether or not to keep the protection order in place. Now, most school administrators probably wouldn't have figured this out, but I had to come up with a solution. And so what I did is I verified the fact that an arrest had taken place and that there was probable cause for an arrest. There were some other factors at play that might identify the case that I won't get into, but I called our legal counsel just to verify, and I said, hey, this is my solution. Based on the fact that probable cause exists, I'm going to trespass this person if he shows up on campus. By me trespassing him, it means that he can't sign the kid out. And that's how I had to solve it, because Idaho doesn't have a process where an officer can issue an emergency protective order right there at the scene based on probable cause. So as far as dealing with kind of some of these complex custody issues and trying to extrapolate out more information, one of the tools that would be really beneficial is an emergency protective order process. That is something that could be added fairly easily, and it is really common in other states, and I'm shocked that we don't have it here. Let's see, I have one other comment, and then I'll open the questions. Oh, schools. So another thing that's a little bit surprising is if your child is in need of an ADHD diagnosis, they go to the doctor, and you know what the doctor does? They send a questionnaire to the school. Why? Because when you think about it, next to parents, there is nobody that spends more time with our children than teachers and administrators. We got them on a 40-day work week. Some of you guys went to 4-day school weeks, but we're still on 5. But we got them 40 hours a week, plus sports if they're there. We see all of the dynamics that are going on. Really, really common dynamic. Child goes to mom. I'm just going to use mom or dad as an example. It's not necessary, but child goes to mom's house 1 week on, dad's house the other week. We will see drastic changes in school performance when they're at mom's versus dad's. And the court has no idea of that because you guys don't send it. There's no questionnaire process. Now, this, I'm talking about adding work on myself. Okay. But I'm telling you that in these cases, the schools could give you a lot of insight because we see the best and worst of mom and dad in the school. When you show up to court, you show up in your, dress and you put on a show. But we see those kids week in, week out, semester after semester, and it's hard to keep that show up. So I just feel like the schools, and obviously this only applies to school-age children, and if you're homeschooling, that's totally different. But with a lot of kids being in the schools, there's just a great avenue there for interaction between the family courts and the school system for getting some of that information out. Any questions?
Maybe, do we have any questions so far? Don't see any right this moment. Oh, Representative Ehart, go ahead.
Sure, thank you. And I have a lot of questions, but I've been taking notes and I didn't get them. Just then clarifying, you'd like us, because I've had him actually do it for the school, though I don't know if it's made any difference. Our AG Labrador to issue then an order or, anyway, issue whatever regarding the fact that they can't, when it comes to credit, that will you just hit me with that one more time?
Yeah, so if AG Labrador would just issue a simple ruling stating that there is nothing in this bill and the language that would exclude forensic exams, and we can get those letters out to all those agencies so that in between now, right, and the time that you fix this legislatively, we can just put everybody at ease. Because there is nothing in this bill that you should read that way. And I understand what happens. You get people in risk management that read something and they just put the brakes on because they don't want to have something litigated. So it just shouldn't be read that way. I mean, it's a very simple reading. So if we could get the AG to solve it, then we don't. My concern is we're going to miss a case in between now and then. And one case is one too many of a child sent home that doesn't get an evidentiary exam. That's my thought.
Follow up. So, and real quick before the question, yes, maybe they're concerned. Also, as we found with other legislation, some just don't like it. They like to be able to do what they want to do without consulting the parent. And even though a child or two may seem to get rid, we have too many kids during a period with parental rights, and so that my concern is with parental rights. Man, you covered so many things. I'm wondering if it might be possible maybe they have, if I can also get your information. But one of the things I found interesting is you said that in regards to ADHD, but generally, if there's 50-50, and oftentimes it's not 50-50, but can you see, because you can see 50-50 in a child's performance at school, one than the other. What happens? Is it as noticeable? It's not as noticeable. Can you still see differences if the kids have just spent, say, the weekend with one parent or the other, where they're getting like every other weekend? Can you still see
Absolutely.
differences?
Parents will talk about this. Parents will talk about the transition zone that happens when you go from rules in one house to rules in the other. We see it in the school as well. There are behavioral issues that we see coming from one parent versus the other, absolutely, without a doubt, and it's patterned over time. And then when you think about the importance of education and the overall functionality of the child. So when you have custody that is 1 week on, 1 week off, right? And it's creating, that means half the school year, you're having problems with school performance. Yeah. And then year after year after year, that starts to build to the point to where now you have a child that is really struggling in school. And of course, those lead to then you start getting into juvenile delinquency, truancy, incorrigibility, because one of the successful factors that starts to build a child's sense of self-worth is their ability to perform well. And what's one of those gauges for them? What's one of the only gauges? School, right? So separating that, when the judge was talking about how do we evaluate good parenting? Well, I tell you what, schools can tell you a lot that goes into that. So why we're disconnected or divorced from that setting, I'm not quite sure. When, like I said, if it comes to ADHD, we have to give this full huge questionnaire on how the kid is behaving and interacting in school, right? So that's just my thought. Again, I'm creative. There may be some administrators that are hearing this that are not happy because it's going to create work for us. But then the other thing this would do, I call it the waterbed effect. Those of us that are old enough remember the old waterbeds, right? You push down something over here, something pops over here. So that's criminal justice in a nutcase. Go all the way back to prohibition. You push down over here, and what do you create? You create Al Capone, the mafia, speakeasies. We still make money off of touring in Chicago and New York, the speakeasies that were produced for prohibition, right? So one of the problems with letting kids have a voice is you're going to now increase the potential for manipulation of those kids, which means you're going to need to counter that with additional sources of independent people involved in the child's life, because you can predict that the minute parents start realizing that kids have a voice, the manipulation on those kids is going to increase. Does that make sense? So then you have to have mechanisms in place to counter that, and the school would be one of your best ones.
Thank you, Mr. Woodall. We really appreciate. We'll make sure that the committee has your contact information, and I'm sure we'll probably have you back. But thank you so much for being on today.
No problem.
Okay, I'm going to go ahead and turn the gavel over to Chair Representative Scott, and she's going to do that next bit of our today. So Representative Scott,
Thank you. We're going to get into public testimony now, and just going to go back over. We have a lot of people that have signed up. We have over 60 people that have signed up, and we're going to stick to 2 minutes. I know that's frustrating, but hopefully you can share. We don't want you to mention names, or we want to fix the process. We have to understand the process. So just keep that in mind. I'm going to ask the committee to limit your questions, please. I'd love to get through everyone. There's a lot of people signed up online. I'm going to try to stick with the people that are from this North Idaho. We do have 3 more hearings that are scheduled. We've just discussed setting up a 4th one that will just be public testimony. So you will have an opportunity. So I want to respect everybody's time, but we do kind of have a hard stop at 3:30. 2 more things I'll mention is there's a group up here that's kind of organized, and they've just brought to our attention. So you might want to stop and talk to them. We've got some folders up here, and there's also another group that's doing surveys and collecting trend information. So if you haven't filled out a survey from one of these groups, or that they're just trying to get the committee information so we have things organized and know how to address this come January. With that, I'm going to just start going through the names, and then I'll probably say the first name and then who's going to be on deck. And then if the next person can be ready to come up as quickly as possible. And we're going to go online and in person. There are 2 or 3 people that were here last time that were actually supposed to be giving testimony. They might be from out of state. We'll try to hit them. And I think we're going to try to start with Christine Morrison, who tried so many times to get on the call last time. If the IT would tell me if she's there. And next on deck would be Shauna and Chris Munger. Okay. So maybe we'll put Christine on deck, and if you guys want to just get going, if you want to come on up, just come up to the podium and just speak loudly, and don't be nervous. Yeah, you can just introduce yourself.
Good morning, Chair. My name is Chris Manger.
And I'm Shauna Mangar. Good morning, Chair and Representative.
All right. Well, we're here today. We thank you guys for coming to hear the people. My name is Chris. I'm here with my wife, and we just want to make note that on July 23rd, 2025, we were served with the court, but we were court-appointed guardians for our granddaughter. We appear before you today to respectfully but urgently ask this task force to investigate and reform practices that have allowed procedural injustice, judicial bias, and disregard for child safety. It's becoming an issue in the family courts. We just want to address some of the things that affected us. The first thing we want to bring out is procedural disparity and judicial bias. Since our appointment as guardians, we have acted solely in our granddaughter's best interest. However, our efforts to protect her have been weaponized against us. Our emergency motions for supervised visitations with the custodial mother, though they were denied 3 times, and each time they were cited as having no calendar availability. While simultaneously, the custodial mother, she filed for a Rule 70 motion, and despite evidence of her past contempts in court, her motion was granted in under 14 days. And at that point, at the July 23rd hearing, without a fair review of our submitted evidence, including documented proof of perjury and contempt by the biological mother, the judge terminated our guardianship and ordered us to hand over our granddaughter to the custodial mother, who 3 weeks prior was deemed still unfit to take care of her. Our second.
Try to wrap.
Okay.
Quick,
Our second point was the failure to act on the perjury and contempt. That was brought up several times throughout our court proceedings. It was never addressed. The third thing was the disregard for due process. So at the hearing, the judge referenced that at our termination hearing, or the motion for the custodial mother, the judge cited that there was a sealed warrant for the biological father who had been trying to intervene and become a part of the court hearing. It was never served or acknowledged, and it was used against him on the day that the case was terminated, preventing him from being preventing him from having the opportunity to get custody of his daughter. So we're calling for oversight, accountability, and reform. We respectfully ask that the task force review the conduct and decision-making patterns of our judges. Also, create an enforcement mechanism that prevents motions from being denied without full review, possibly from peer judges.
Thank you so much.
All right.
Testimony today. And if you have a written testimony, you want to send it in to our secretary, she will get that into the file, so we'll have access to all the full testimony. Thank you so much. Next up is Christine Morrison. Is she on?
Hello? Hello?
Hi, you're live. You get 2 minutes to share.
Okay, my name's Christine Morrison. Thank you for the opportunity. I wrote the book, Judicial Criminals, the Greatest Fraud Upon American Society, America's Legal System. My webpage is judicialcriminal.com. I am a crime victim of the state of Michigan, 15 years of injustice. My case starts with a consent judgment that was amended twice. The judgments were entered without my consent, signature, knowledge, and without the informed consent of my legal counsel. This violates the principles of due process, procedural requirements of a valid legal agreement, and contract law. I have had up to 10 appeals in my case, 1 attorney malpractice trial, that I was awarded close to $220,000 in the court, and it was appealed by the then attorney, and the Court of Appeals reversed it in his favor. He liquidated $80,000 from my retirement accounts illegally in violation of state statutes, court rules. I have a motion August 11th where I am asking Michigan, the court, to declare the settlement agreement and the amendments void, because Michigan law says that judgments entered without valid consent or jurisdiction are void. It's a legal imperative, not a discretionary matter. I want what the state has done to me reversed, and I want the perpetrators held accountable. My attorney wrote a letter to the Attorney General, Granholm, who said, sorry, can't help you. You have to appeal the issues. You cannot appeal in a 15-year period countless illegal court orders entered against you. I was deprived life, liberty, property, and criminally extorted from. My only child.
Tina, you're out of time. We appreciate your testimony today. And if you have this written down, we are happy to put it into the record. And we're going to go back to some people from Idaho, and we're sorry we didn't catch you last time. Tina Stevens, is she here? And on deck would be Colin Everhart.
Madam Co-Chair and committee members, I'll be as quick as I can. I'm here from JCP Concerned Citizens, primarily to address 3 issues. All the documentation is yours to take home and take a look at, and mainly court reform, judicial elections, and client attorney relations. I'm going to go backwards, easiest to hardest. I think Idaho needs to have a Bill of Rights that's provided to clients when they retain an attorney, so they know what to expect. I hear many cases currently are costing $150,000 to $200,000 for like a 2-year case for attorney fees. So I think that would be helpful. 7 other states have a system whereby judges are rated, and that information is given to the electorate, to the voters before election time. We have a wonderful template we can follow from the Supreme Court of Idaho called the Judicial Feedback Survey, and we can get that feedback from both attorneys and litigants very easily and electronically. So please read what I said, and you're happy to contact me with any more information. And then the third and hardest is court reform. There's many things we need to do to cut costs, to stop suffering, cut down the number of cases. I think we can save hundreds of millions of dollars a year if we adequately reform the system. And if we implement these reforms and really stick to it, I think we'll be attracting fantastic judges to the bench. There are many attorneys in this state that would love to be judges if the system would change first. So in here, I've made this available online as well. It talks about judicial oversight, ways we can tweak that, how we can educate our judges better, help them do their job, how we can restructure the allocation of cases to better serve the public. Talking a little about some things that need to change, like jurisdictional things. And then talking also about standardization. There's some systems we can put in place. I've been an administrator for 40 years in the private sector and an educator. There's many ways to systematize things with judges, guardian ad litems, parenting coordinators, et cetera, that save a lot of time, cut out tons of litigation, and make the system more efficient. So I'm not going to take too much of your time, but I'd be happy to start conversations about many things we can do.
Thank you.
Thank you.
It looks like you put a lot of time into this. Is this something that, when you say it's available online, is that available to the general public or just to us, or?
Just to you right now, but we can change that. I've been working on this for 15 years, and my vision of reforming the family courts has been, just percolating for 15 years. And I know we can make a huge difference in many of the things that we've heard today.
Would you be willing to come back and maybe at the next hearing and share some more?
I will dedicate any time necessary and I'll fly to any location.
Okay, you can always do it. Fallon, is Fallon here? Phelan Everhart? No, how about Lana Monter? And then on deck, we'll have Clark Gadsden. Okay, or Derby.
Okay. I worked to edit mine down while I was sitting back there, so we'll see how I do.
Okay.
I would ask of everyone present and joining this hearing from afar whether the following actions are indicative of healthy parenting. Threatening and obstructing law enforcement while being served for custodial interference. Withholding children for months and years. Stalking by showing up at co-parent's home repeatedly during off-duty hours. Assaulting and kidnapping a child with witnesses. Sending children with a withheld key to break into the co-parent's home. A new spouse impersonating the other parent in medical and school matters. Ask yourself, are these the actions of a safe and stable parent? Could you co-parent with someone doing these things? Coercive control is a chosen pattern form of domestic abuse that includes isolation, threats, humiliation, and manipulation. It is insidious and often invisible. Judicial terrorism is when an abuser uses the legal system to continue their abuse by dragging the victim into endless court proceedings, forcing contact, draining financial resources, and weaponizing child custody as a tool of control. In custody litigation, child custody, actions that would be criminal elsewhere, such as stalking, harassment, financial abuse, even kidnapping, hide behind the ambiguity of legal filings. The abuser drains the victim financially and emotionally, and claims they're unstable or unfit because of the very damage they caused. Victims learn that no one is coming to help, that there is no protection, especially when children are involved. If attorneys and judges aren't trained to recognize coercive control or weaponize judicial terrorism, can they truly act in the best interest of the children? We need better training. Survivors bring vital knowledge. They understand the patterns, the endless legal loopholes, and the horrific emotional toll on children. Their insights should be part of creating improved legal standards and court practices. As we saw in the Gabby Petito and Decker children cases, a lack of training and knowledge can cost lives. For the safety of our children and for the future of our courts and communities, this must change.
Thank you for your testimony. Representative Ehart.
Quick question.
Question for you, Lana.
Yes. Thank you, Madam Chair. Lana, you happen to talk about attorneys, et cetera, needing more training because of these legal filings, emotional, yada, yada. Do we really need that? Are we suggesting that the attorneys don't know what's going on?
Go ahead, Lana.
Or they may know what's going on, but they don't care, or it's just not something that they want to deal with. Because it's messy.
I think we know it's
messy. So.
Thank you for your testimony today. Is there a Gertie here? G-R-T-I-E? No. Okay, how about Jessica McMurray? Jessica McMurray here? All right.
I believe she's online.
Is she online?
Yeah.
Yes, she. I realize she's from Alice State. Her case was here.
Her case is here.
Her case is here. Yeah, recently. Okay.
Are you able to hear me?
We can hear you. Yes.
Perfect. Okay. Thank you so much. My name is Jessica McMurray, and I'm coming to you today as a local, but also as a victim of the North Idaho court system. I'm coming to you to discuss the domestic relations pertaining to the protection orders that we have in place. I also submitted some documents to you guys from Arizona that I think would be beneficial. As it stands right now, it is extremely difficult for victims to get protection orders, extremely hard to get harassment orders, which I think we need to separate protection orders with harassment orders. Myself and my daughter are currently being harassed and stalked by an ex-friend. I've been denied 2 times by 2 judges that have been here today speaking to you guys due to the quote unquote intent. There's been large law enforcement reports. The paper trail is endless. Most recently, my daughter was almost hit by an erratic driver because of this person. So I come to you today about judicial bias. Hopefully we can change that. but also about changing the laws and regulations surrounding protection orders. I believe we also need to have something in there for reform about petitioners violating protection orders as well. And also perjury needs to be considered more of a crime than it is in Idaho. Our police forces work so hard to do their due diligence, and right now their hands are tied just because of what our laws say in section 187905 through 187907. So I asked today that we do better. We need to do better and to start realizing that there is judicial bias on our judge panel, and this needs to be taken care of. Thank you.
Thank you for your testimony today. We appreciate it. Next up is Tyree Strong. Tyree here. She spoke last time.
Good afternoon. My name is Tyree Strong, and I am Strong Family Law here in Coeur d'Alene. I'm going to talk a bit fast and skip some parts in order to get through this. Today, I want to speak about judicial discretion. Our magistrates have tremendous discretion regarding custodial decisions, making it impossible to predict outcomes. The only statutes that direct our judges are Idaho Code 32717 and 32717B, which list factors that must be considered in making custodial decisions. The only direction they provide is that there is a presumption of joint custody unless one parent is a habitual perpetrator of domestic violence under Idaho Code 396303. Yet there is no definition of habitual perpetrator. I argue that the standard should be merely a perpetrator. Someone who has committed physical or sexual abuse of a household member is not a safe parent, as is shown in the studies I shared at the last session. I believe that if someone has perpetrated domestic violence according to Idaho Code 6303, including coercive control, which I encouraged you to add to the definition last time, that there should be a presumption of sole custody unless there are clear findings of fact as to why that is not in the best interest of the child. However, if you disagree, I urge you to at least define your intent as to what a habitual perpetrator means. Because without a definition, judges seem hesitant to find that someone has habitually perpetrated domestic violence. And therefore, even with multiple instances of domestic violence, still grant joint custody or even sole custody to the abuser. The standard has become too high and children are harmed. I've seen a judge deprive a parent of all custodial time without a finding of fact that the children would be harmed in her care. I've seen a judge deprive a parent of all contact without a finding of fact that indicated even telephonic or supervised contact was a danger to the children. We need standards of minimal findings of fact for such strong decisions. To take away a safety check on how the children are doing by removing all time or contact with a parent needs both a finding that the non-custodial parent is a risk and a finding that the custodial parent is safe. Thank you.
Thank you. Do we have any questions for Tyree? I have a question for you. So you're in family law, you're a lawyer then for family law. And so we're going to become your new best friend because we keep hearing that a lot of lawyers are not wanting to be involved in family law because of some of the issues in court. They say it's not worth it. You're going to lose this. Have you found that you're getting busier? Is there more people coming into the field of family law?
I don't think there are more attorneys coming into the field of family law, but it would be hard to know. It is hard because you don't know what's going to happen.
Okay, thank you for your testimony today. Michael Hodgson. When you're ready to state your name and start your testimony.
Thank you. My name is Michael Hodgson. I'm an attorney licensed in Oregon, Washington, and Idaho. I work with the Idaho Legal Aid Services as a subcontractor to help people who don't have the financial resources to hire their own attorney. As part of my contract, I also represent clients with the Coeur d'Alene tribe. I intend to present a white paper to this committee on this subject, presenting, number one, a brief history of judicial activism, starting with the arguments of the Federalists and the Anti-Federalists, discussion of the legal standard of best interests of the child, the constitutional right to parent a child, a section addressing the argument against judicial oversight as being violative of judicial independence and necessary to protect judges from overreaching by the legislative and executive branches. And finally, recommended solutions from myself and my friend Tyree Strong, who just spoke, among others, Tina Stevens, with vetted solutions that we've tried to come up through our collective experiences. At the outset, I would like to reiterate, I am only an attorney. I have not suffered, as many of you here today have suffered, at the hands of judicial activism. My outrage is as an attorney who went to law school because I love justice, and I hate seeing it undone for innocent people like yourselves. And I am sorry, in my office, as an officer of the court, as an attorney, I apologize that we have failed you, but I am here to try to make a difference, as is Tyree and many others. There are attorneys that want things changed, but perhaps are afraid to speak up because of the backlash against them in court.
And did you say that you had a white paper, or it's not finished yet?
I started it. Tyree's agreed to help me with it. I'd imagine my friend Tina Stevens will also help me with it in her 15 years of collecting this wisdom. I've been practicing law for almost 14 years myself, and I've seen this injustice since the year I started with my very first case.
You do have a contact, yes.
Thank you.
Thank you. Brenda Hagel, and on deck's going to be Rachel Schlattback. Is Brenda Hagel here? Online, maybe? No? How about Rachel Schlattback? Yes, she's online. Let's grab her.
I'm here.
Hi, Rachel. When you're ready, just share your name and your testimony.
Okay. I am Rachel Schlabaugh, and I just want to bring to your guys' attention that I have a case. I had went to the court for a protection order for my daughters who are under 3, and for my ex-husband sexually abused me. He was really deep into porn, and we had one of my daughters came back from him with frostbite, and I had all of the evidence, and the judge, she gave me a protection order but sent my 2 daughters back to him in 50-50 custody. And it's like the court system waits for, how can we protect our kids when the court system won't let them, or will put them back into that situation and wait for them to be molested before they do anything about it. That's what I wanted to say.
Rachel, is that all your testimony?
Yes.
No, I was unclear. If you could just clarify real quick. You said that the kids came back with frostbite. Is that like real frostbite from being in the cold, or was it something sexual?
No, it was from the cold, actually. Yes.
Okay.
He doesn't take care of them very well.
Got it. Okay, thank you for your testimony today. Next up is Yvonne Garaway. No? Okay, we'll come back if I don't pronounce it. Shelley Hawkins. Yep.
Hello, I'm Shelley Hawkins, and I've been a resident of Kootenai County for about 11 years now. I'm here as a grandparent. My son was here earlier but needed to go. Basically, I'm in support of him fighting for custody for his now 4-year-old that was taken away from him on a false protection order that had him removed from the home and was never able to enter his child's life again. We've been in court now for 2 years. The subject matter of these court cases have been basically it's kicked the can down the road by her and her family, excuse me, changing lawyers or getting public defenders, or in case nobody knows, you can fire a judge. So every case that she's been involved in, including a abuse case against me, almost breaking my nose and my cheekbone, she has appealed all those cases, and she has filed a judge in each case. So with that, also we have a parental interference case with her to try to go on the criminal side because we weren't getting anywhere civilly. Civil wise, we're now into another year of waiting. We have a new judge due to the fact that 4 of our judges at the last minute recused themselves from the case. In a recusal, we are told that we are not allowed to know the reason that they recused themselves, whether there's a conflict of interest, they know somebody. Very, very weird situation, since she has been in trouble multiple times, and excuse me, some other family members, and they've all been in front of these judges. So anyway, we're just we're at a quandary of what to do. He hasn't seen his son in 2 years, and the cases just keep getting postponed. So we do have a new judge now. We don't know what's going to happen. We are trying not to use the legal system abusively, as she has filed motion after motion with false allegations. Those false allegations seem to go somewhere with the judges, but just going in there and blatantly telling the truth goes nowhere.
Thank you for your testimony, Representative Ihar.
Thank you, Madam Chair. Yeah, this is something that's been a concern. I probably have gotten that. So I'm just trying to make sure I understand. In all this time, he hasn't been allowed to see his child?
No, the custody order was February 8th of 2024. He hadn't seen his child for the year prior to that, when she had him kicked out, and we waited to get in court for a year.
And quick follow-up.
Go ahead.
And so it just clarifying then, I don't know how many we're talking about, 5, 10, motion after motion, judges recusing themselves. So there's always been something that did not involve you all.
Correct.
How many motions?
No less than 10.
Okay.
I have one question. Has your son done anything, like he's got no custody, but has he done anything criminal? Has he been into drugs, or is there any reason why he didn't get any custody?
So he has 50-50. He has 50-50 legal, 50-50 physical, 17% so-called visitation parenting time. She never shows up. So, and every time we go back into court, it's brought up, you know, what are we going to do about being able to see, what is he going to be able to do about seeing his son? And the judge dismisses it and says, oh, you've got a modification, by the way, February of 2026.
Well, we're going to go to Co-Chair Nichols. Go ahead.
Thank you. Really quick. So no supervised visitation then at all. So nothing whatsoever on top.
Representative Ihar, you have one more?
Yeah. So, Madam Chair, and Ms. Hawkins, during this process, has he had to pay any child support?
Yes. Yes.
Has he paid it?
Not all of it, no. They put him $8,883 in debt the very first day. He went to court for a year that he didn't get to see his kid with no court orders in place. So he's in debt right now, over $16,000. They've taken everything away from it, and including a fishing license. But he needs to go to work, right? So he needs to go to work. So just one little extra thing. I am astonished at how many professional people got up here today. Sorry if there's going to be tears, but the fact that we can get up here and talk to a board that's willing to help, and all we presented was Kootenai County looks good. Kootenai County doesn't have any problems. Kootenai County's doing a great job. CPS is doing a great job. I'm in the trenches. I go out and look for people that are in this situation on purpose, and we're not doing a good job.
And that's why we're here today to just get testimony. So we thank you for your time today. And we're gonna move on to Preston Hawkins. Preston here?
He had to go to work, that's my son.
Preston had to go to work. Okay, maybe you can let Preston know that we will be doing online stuff later. How about Michael Shovey or Shovey? No, he doesn't want to testify. Kevin Johnson. After Kevin, we're gonna have Erica Goodney. No?
Yes.
Now you have to pick the other ones. We got where you're from, Kevin Johnson.
Kevin Johnson, Sandpoint.
Oh, Johnson.
First and foremost, I'd like to thank the committee for taking time and addressing the situation that we have here in Idaho. And it's not just Idaho, it's nationwide. So today we've been hearing testimony from several professionals, but it all is surrounding the court system. My situation is a little bit different. The court has not been involved with my case, and it's a child support case. I've had full legal physical custody of my son since 2012. 2018, the biological mother filed a child support case. Fraudulently, obviously, I had full custody. She had also lost her parental rights back in 2012 when the custody order was given. Today, I find myself dealing with child support services. I'm a deadbeat dad that hasn't paid child support with my child in my custody the entire time. All of these actions against me, including losing my driver's license, I'm upset. My driver's license and fishing license has all been done through administrative procedures. So no court involvement. This administrative law judge has no jurisdiction, has no authority. I question whether or not he even had subject matter jurisdiction. And again, after a 2-hour telephonic conference with this guy, of course, he found in favor of the state child support services. So I wanted to bring it to your attention, everybody's attention. It's not just courts. Thank you for your time.
Kevin, I have a question right away.
Yes.
Have you contacted your state legislator?
So,
let them know about this to kind of intervene because
that's my major. That's why I'm here today was help.
No.
So I spoke with Director earlier after his presentation, and I was watching his facial expressions and just the whole demeanor, and ultimately it was, wow, that's kind of a pretty big situation. I don't know how to help.
We'll help you.
Anything.
We'll figure this one out. Okay. Okay, let's move on. How about Kevin Johnson from somewhere else?
Well, this was kind of long and lengthy. Thanks for having me from Post Falls.
Great.
So I'm not going to go through it all. Plus, my ex-wife's attorney's in here, and I'm not comfortable speaking for her. So
You're
I'm just
welcome
going
to call us privately too if you want to follow up after, so it's not on the public record.
Yeah.
So what do we got?
I will just say that our case lasted 4 years, cost over $200,000 for myself. There was clear and obvious abuse allegations. CPS did a report. The judge ordered a report by CPS at the end of our trial. It's all in here, and all the kids admitted to. Excuse me, I'm nervous. I'm sorry.
Take a breath. We've got time.
Kids admitted to years of abuse, bruising with belts, bloody noses. Kids are scared of their mother. The judge read all this, still decided in favor of the mother, so I only see the kids 10 days or 8 days a month. They're fallen 3 years behind at school. Two of the girls live with me. They got caught up in school after they moved in with me the last 2 years, but that was just them pushing to move in with me. It wasn't court ordered.
Try to speak up a little bit so we can make sure you hear.
Yeah, sorry. Anyway, I just, after hearing that lady speak down there, I think the whole process changed. I think there needs to be intervention from outsiders and not just attorneys going and saying what is on their mind, what they believe is wrong or right. And that's what all the judge hears. And the guardian ad litem's immediately. There needs to be some kind of intervention for these children. My kids are anywhere from the range of 5 years old to now 19. And throughout the 4-year process, none of their voices were heard. 17, 18, 16, 14, none of them want to live with their mom, but yeah, they're being forced to, even with evidence, still to this day, and school neglect to this day. So anyway, I just think the entire process needs to be changed.
We have some questions for you, Representative Alfieri.
Thank you, Madam Chair. I just want to ask a question just for clarification.
Yes.
Are you saying that, did you say that the children testified to physical abuse by their ex-wife?
To CPS, yes, and there's a report.
And there's a CPS report?
Correct.
She was still there?
Yes. And the judge read it very clearly. And it had been going on since they were, younger, bloody noses, with belts. So yeah, none of them want to live. My 10-year-old son was crying, saying he's scared of his mother, but yeah, he's forced to live with her. So not a good situation.
Representative Hart.
Madam Chairman, so in deciding how much you got to see the children, was there a reason cited, you yourself being abusive or not being a good parent?
The CPS, well, they accused that from the beginning, and that's why the kids were limited to me in the beginning. But then we had a parenting evaluator come in, and she spoke to the kids, spoke to everybody, and that was all, proven to be false. And the kids all admitted in the CPS report there was no prior or present abuse by their father.
Thank you for your testimony today. We really appreciate it. We're going to hit some digital testimony. Chris Greenfield, are they online? Or are they here? Chris Greenfield? Nope. How about Troy Thompson? Nope. How about Kelly O'Toole? Oh, she's out of town. Stephanie Shepard? Yeah, you got Stephanie. Stephanie, are you there?
Are you able to hear me?
Yes, we can hear you. Go ahead.
Okay. Thank you. Thank you so much, representatives and members of the committee, for holding this hearing, giving families like mine, families who have been silenced, the opportunity to be heard. My name is Stephanie Shepard. I provide my testimony under oath. My concerns are extreme: judicial bias and child safety, the best interest of the children standard, due process, perjury, fraud upon the court, constitutional UN convention, and universal law right violations, and custody theft. I currently have no custody, legal rights, or contact with my children. I was a stay-at-home mom, all-American, white picket fence, traditional wife, life, picture perfect. He called me the submissive in the suburbs. There was physical violence while pregnant twice, verbal abuse, extreme cruelty. I suffered a pregnancy loss at 20 weeks, isolation, financial control, gaslighting, verbal abuse to me and the kids, isolation from family and friends. It was a 10-year marriage, 5 children. By the time I petitioned the court, we had been abandoned for 7 months. I confirmed massive, multiple tens of millions of dollar Ponzi scheme, infidelity, which were felonies in Idaho at the time. He told me to be an accomplice or he would crush me. He said that the court was on pay because he had hired his specific attorney. When I told him he was breaking the law, he said, I told my attorney he knows I'm all good, indicated his attorney high-fived him. He said they all do it, that the judges and attorneys are all liars, cheats, and thieves, that they don't give a crap about me or the kids, that it's all about the money. And because that he had his particular attorney, that I was crushed. He dragged out litigation. He said I would see that this was Idaho judge and it was Idaho law. He disclosed a mental illness diagnosis to me. He is self-aware. He said he was aspiring to psychopathy. I advised my own counsel. They told me to be silent as to not disparage him or the court. $3 million in cash in the accounts, mostly investor funds that I did not know we had. No transparency, redacted financials. He ran off with the secretary, rapidly began dissipating the estate on worldwide travel. There were 41 flights he went on during our divorce. It is a made-for-TV movie. The grandiosity was off the charts. I had no access to income. I was shut out of everything. He objected to every subpoena. I begged for a receiver 3 times to protect the community estate, the children, and investors. I was denied every single time. I was told no. I was told to pay for evaluators, accountants, special masters. He identified me 7 times, forged signatures, $27 million in felony loan fraud. Found out about his upbringing in a pedophilic cult. He owed his ex-wife $130,000 back child support. I went to trial with no income. They exhausted $172,000 HELOC, the attorneys did. My home was liened for $135,000. He was impeached for perjury. The judge didn't care. He always seemed to know in advance what the judge would do, saying what he would do as if the outcomes were predetermined. Pardon?
We gotta need to wind it up a little bit here.
Yeah.
We're out of time. So
yeah, thank you. Thank
right
you.
Now, do you have any custody right now?
I do have no custody right now. No, he's come and he's taken the kids. He got an ex parte hearing. I was unable to get to the courthouse because I was across the country. Everybody knew that. And I was not present at the hearing about me, and he got an order for full physical and legal custody. Has taken the kids. I have no contact. I have no attorney. My attorney filed to withdraw. I don't even know what to do.
What county are you in, Stephanie?
In Ada.
Thank you for that. We are coming back down to Ada County, and we're going to encourage you to show up in person down there. It's going to be in a couple months. But thank you for your testimony today.
Thank you.
Okay, so many to choose from. How about Grace Henderson? Is she here? Okay, come on up, Grace. And Andy Shaw's going to be on deck.
Hello, my name is Grace Henderson. I'm from Kootenai County. My divorce took place in 2017 in Bonner County. I have been threatened with jail time twice by a judge, once for reporting abuse during my marriage and not calling the cops during this abuse. And she told me that if I didn't report suspected child abuse in the future, I'd go to jail. And then a second time when I did report suspected child abuse, she threatened me with jail time if I continued to waste the court's time, and told me that I would be held accountable for the bruises on the 2-year-old. I'm sorry, I had a better one. I was given weekends when my sons were 4 and 2 years old because they were in daycare too much. All my family is in Georgia, and during the time of our divorce, this was disclosed, and she told me that when my sons were in my care that they had to be seen by a licensed daycare provider or blood relative to myself, and then took them away because they were in daycare too much. 2 days a week, not even 8-hour days. I am in fear of going back to court to petition a change of parenting plan. My current parenting plan has me with my sons for 1 month in the summer and 4 days at Christmas break every other year and every other Thanksgiving break. I have no record of abuse, alcohol abuse, drug use. I have a couple speeding tickets. That's my record. And yeah, I live in fear of this judge. She said it's her case and that it will be her case forever, and told me I could not leave her jurisdiction.
I'm gonna have to ask. What county?
This is in Bonner County. My husband and I lived in, my ex-husband now, but we lived in Bonners Ferry. And when we separated, I moved to Kootenai County and he filed for divorce first. And so it went to Bonner.
Thank you for your testimony today.
Thank you.
Andy Shaw.
She left.
Okay. James Wilson.
Well, thank you all for being here and for hearing me out and everybody else. I got to tell you, some of the stories I've been hearing the last hour, what I have to tell you is a skin knee. What I'm going to tell you anyway. During my trial or during my divorce, it began with a civil protection order that was issued against me for which there was no evidence, and of course it was dismissed because there was no evidence. That was in August of 2022. In May of 2023, my ex-wife filed a CPS complaint against me, claiming I was either molesting our daughter or grooming her or both. Again, she couldn't even come up with an example of my abuse, and so it was unsubstantiated. The CPO was ex parte or ex parte, and then it was dismissed. When I tried only a few weeks ago to do the same thing because my child was visiting here from Australia, I'll get to that, but I was refused the ex parte because they said I showed no substantive evidence of irreparable harm to the child when she went back to Australia. They didn't do that with my ex. The reason I'm even telling you about these things is because the CPO and the CPS complaint were admitted as evidence in the findings of fact and law after they'd been dismissed, and therefore I had no opportunity to speak against the CPO in the beginning or even when they were used as evidence. We appealed to the state Supreme Court, and the opposing attorney literally fabricated new evidence during the hearing, not allowed to introduce new evidence, even if it's true. That was accepted by the Supreme Court. And in addition, one of the justices interrupted my attorney making his argument so frequently that our time was up. We didn't get a chance to share even half the argument. Despite the clear language of the statute for frequent and regular visitation, the fact that our parenting time evaluation recommended against relocation to Australia, the judge allowed my ex-wife to take our child to Australia. I could talk to her twice a week, and she's just returned. We had our 2-week visitation. I tried to file some action at that.
Time's out. You wrap it up a little bit.
Sure. Just okay. Here's what I'm recommending. These judges, and I mean no disrespect, but they act as though they think they're gods. And the reason they do is because we treat them like gods. It's us. It's on us. So I want to see some changes in accountability and in the immunity that we protect. They need to have qualified immunity, but not when they're trampling on people's constitutional rights. Judicial rules must not be permitted to trump constitutional rights, which is what happens now. The Supreme Court dismissed our action because they said everything was done according to judicial rules. That's all they cared about. It's the judge's record from for re-election. They should be made public. It should be the case that the rules apply equally to both parties, not just to one. And there should be an opportunity when a child is articulate. I don't want to put my daughter on the witness stand, but it ought to be required that if the child has something to say, the judge hears it, and that needs to be a change. Thank you very much.
Thank you so much for your time.
You bet.
We have a special person in the room, Representative Rachel Bishop from Arizona. She'd asked if she could have a minute to share what's happening in Arizona. So go ahead when you're ready.
Yes, thank you, Madam Chairs and committee and everybody here. About a year ago, one of my colleagues brought me a family. And so many of the stories that I'm hearing now that I've heard in Arizona, they're all similar. They all follow a blueprint. It's not just Idaho or Arizona or Alabama or California or Michigan. It's a nationwide problem. And, you know, they say there's no crying in politics. This is one of those things it's tested me in that way. because that one family had spent $4 million trying to make sure that their granddaughter was safe. When I first met them, they had a judge, they had an attorney on the case that was falsifying evidence. They had a judge that was continuing to threaten arrest for the mom for nothing. And when I started to push back with legislative inquiries, staying in my lane, my old house was almost burned down. I was getting phone calls from DPS at the Capitol, checking in on me from Mesa police detectives. So I want you all to understand one thing. They didn't know I mean very well because I don't scare easily. And here I am a year later, and here I am looking at you heroes who I know this isn't easy. You get a lot of pushback. I know that. And I want to leave you all with hope. All of the parents in here, it's not all of the judges, it's not all of the attorneys, it's not all of the therapists. It's some, it's a handful. They have figured out how to exploit a very broken system. Some of the parents have figured that out. The attorneys have figured that out. And what's exciting and what gives me hope is we now have people that are coming together from many different states to figure out how to fix this, because the ones that suffer the most are the kids in these situations. I have 5 kids of my own, 3 stepkids, 8 total. I love kids. And when I hear these stories and I see bruises on children, pictures of bruises on them personally, and I know they're being sent to an abuser on a regular basis, that lights a fire inside of me. So I just want to encourage everyone in here, this group of people, you have some really good attorneys in this room that care. I want this lady right here to come to Arizona, or at least get the number.
Yeah.
You have a sheriff in here that gets it. There are good guys here that are ready to come together and fix this. And you have a whole group here that are listening to you. And I just want to leave you with hope that we're going to keep working. We're going to get to know each other better. And I do have contacts in the White House that I'm working with right now. So I want to give everybody here hope. Keep pushing. Let's grow our coalition so we can get somewhere and finally fix this. Thank you.
Dear Francesca Arazo. Yeah. Ari He.
She's there.
She's there. Oh, yeah,
She is?
She didn't want
She didn't want to testify.
You don't want to testify? Okay. And then on deck, we're going to have Frankie Refstan. Go ahead, Ari.
Greetings, meeting. I could tell you about the 2 boxes of case files from trying to be the father of my 2 daughters. I could tell you that the largest document in there is an affidavit from a woman from Catholic Services during a CPS investigation that turned to find nothing, but my 4-year-old daughter had to be subjected to playing with anatomically correct dolls. And I could tell you about a fine young 8-year-old that lost her father in Ontario because Ontario will not respect the Uniform Child Custody Jurisdiction Act that they've signed on to. I could tell you about spending the day with the RCMP trying to get a visit up there. I could tell you that my now 41-year-old daughter, I learned at lunch, is in Portland getting parts for her car. She doesn't talk to her family. She has Lyme's disease and other issues, and she has some serious mental health problems as well. And there's nothing her family can do for her because she won't communicate with us. But I want to talk about the solution. The judiciary is a frigging rotten mess. They engineer for themselves absolute immunity, which is absolute corruption. And the Idaho Judicial Council is a farce and a fraud. If you review what they've done, the first 1,000 complaints that they've received, they've given 1 slap on the hand. I've been at this for a very long time. And so I want to run out of time, but I want to bring attention to, I'm the co-author of the Idaho Judicial Accountability Act. And this was a 2006 initiative which failed to get enough signatures. In very short terms, it creates a citizen grand jury that's permanently installed so people can bring judicial complaints to a grand jury to review, to protect judges from frivolous stuff, but also to give an avenue to bring justice to our injustice system. It's a friggin' mess. There's lots more I could say.
Thank you for sharing your testimony
And
today.
you all know how to get a hold of me, so
Thank you.
thanks.
Catherine Redford, is Catherine Redford here? Is it Bedford? How about Bedford? Bedford. Close. Gotcha. Good afternoon, chairs and committee. Thank you for being here today. I am here for a reason, not a custody or an abuse reason, but for a CPS reason. And hold on a second, I just lost my form here. Back up. Sorry. Who I am is I am a witness to a system that has failed, I believe. I have a tenant that lives in a unit of mine who had his three grandchildren removed by CPS when his daughter, who lived in the same house, got taken into custody and has mental illness. So I've watched firsthand the injustice of the blatant misrepresentation and the failure to follow state law. I have seen the false and fraudulent affidavit filed by the Kootenai CPS social worker to influence the judge's decision to remove the children from a fit and willing caring family member into the custody of the state. Despite notification to many officials about the egregious offenses, nothing has been done about this. We have talked to the Department of Health and Welfare. I have talked to the AG. I have talked to our prosecutors. We have submitted this evidence to everyone and nothing has been done. This affidavit was the start of removing the children from the grandfather's care. He had custody of the children. He was allowed to have custody of the children until this affidavit was written and given to the judge to allow her to write the order to remove these kids from a fit and caring grandparent. The affidavit lied in saying that both the grandparents who live here he lives here in the state, grandma lives in Liberty Lake, that the affidavit told the judge that both the grandparents said they were unwilling to take the kids and that they would be better off in the custody care of the state, which was a complete and utter lie. In the meantime, grandpa got foster care licensed, kinship foster care licensed in December. These kids were taken in August. He got foster care kinship licensed to be able to get his kids back. The CPS office has done nothing to facilitate that. We promised and been promised to get those kids back, and they've done absolutely nothing. I sat here today and watched them on that screen saying that 80% of these kids are taken and should never have been. This is the same case. The judge knows nothing about him. He has no rights, no standing, no nothing to be able to present anything to a judge in the case, even though he's tried several times. The parents, if you're not a mom or dad and you're a grandparent, you cannot get in front of a judge to be able to present any evidence. He has no idea that he even exists.
I appreciate your testimony today. We're gonna skip the questions. I have about 35 more people that
Okay.
testify, but I'm going to encourage all of you to follow back up with us individual legislators to dig in a little deeper. Please do that so we can get some actual names and follow up on some of this stuff. I just want to get to as many people as possible.
I'll talk to you about that.
There's so many people on the list and I just feel guilty that they've made the trip. Betsy Black, is Betsy Black here? And after Betsy, we have Casey Wall.
Good afternoon.
Thank you, Betsy.
Thank you. I am a family law practitioner. I graduated law school in 2003. My background is social work, so I've got an undergrad in social work. I was a former prosecutor and I started my law practice in approximately 2009 and exclusively practiced family law. As a part of my practice, I'm also a.
Barbara, excuse me, 1 minute. We're going to ask you to do this afterwards or in the hallway, please. It's just too distracting.
As part of my practice, I also do mediation. I'm a guardian ad litem. I'm an attorney for children. So what I would like to really emphasize to the committee is the complexities that judges, practitioners, evaluators have to deal with when they're dealing with allegations of either domestic abuse or parental alienation. What I want to emphasize to the committee is this is not an easy problem to solve or evaluate, let alone make a best interest decision for children. When we talk about parental alienation, it is just one component of an overreaching idea or problem that we have in our court systems, where we have kiddos that either resist or refuse to be with a parent. So oftentimes what we look at is these cases are classified as either parental alienation cases, or they're classified as domestic violence or abuse cases. And so generally speaking, the alleged abuser will say that the other parent is engaging in parental alienation and undermining their love and affection for their children. And the parent that is the favored parent will say that the other one is the abuser. It's much, much more complicated than that, because what we have is we have enmeshment that often occurs in these cases, where there is unhealthy boundaries between the parent and the child, where the parent will either get their emotional needs met from the children, or they will overshare adult information with their children inappropriately and bring them right into the conflict in the middle of the divorce or the custody modification action. Sometimes this happens even before parents separate. And then we've also got like legitimate estrangement, and that's where domestic violence comes in, or coercive control comes in. So that's where we have a parent who has done something in the family unit to justify the child's not wanting to have a lot of time with them or any time with them whatsoever. Then you have natural alignment, which is just based upon parents' personalities, kiddos' personalities, and just generally speaking, they might align better with one parent because they're both introverts, or they both like horses, or they love fishing or hunting or whatever it is. And that's normal and that's natural, and it happens in every single family. But what we often see in these cases is this umbrella of problems, which is parental alienation, domestic violence, coercive control, enmeshment, alignment, parentification, infantilization. And it takes a tremendous amount of resources and effort from practitioners like me, evaluators like, parenting time evaluators, brief focus assessors, things of that nature, guardian ad litems, to actually figure out what's going on in the family unit. And that's why a lot of these cases have so much money being spent on attorney's fees, because they are not easy to get through.
You have time. Okay. I am going to ask that we come back, maybe even do Zoom at a different thing, and we can get deeper into this, because these are words that we have heard that aren't even in our code. We don't have a definition for parent alienation, but the fact that they're using court orders and using that terminology. So we'll ask you to make sure you leave your information with our expert testimony.
Absolutely.
And we'll give you some more time. All right. I thank you for showing up today. Appreciate that. Casey Wall, is she here? Come on up, Casey.
Thank you. Good afternoon. My name is Casey Wall. I'm an attorney, family law attorney here in Kootenai County. During college, I worked full-time at a children's home for children that could not be placed in foster families. I graduated college in 1997 with a degree in history and all educational requirements to teach, including childhood development, child psychology. After I graduated college, I ran the boys' home that was part of the children's home, living on site with the children. I did a significant amount of training that was required before I could be a family placement, essentially within the home of that boys' home. I taught school for 1 year after that, and then I went to law school in Little Rock as a dean scholar with a full scholarship and a desire and commitment to learn what I needed to do some good in this world. Immediately after graduating law school in 2001, I served as a law clerk for the Honorable Morris Shepard Arnold for the United States Court of Appeals for the Eighth Circuit. After my 1-year law clerkship, I worked as an associate attorney at a Little Rock law firm. And after practicing 4 years, I came back to Idaho, which is where my family's roots are. And I found my niche then in family law. I adopted my son through the foster care system within a year after moving back to Idaho. And currently I'm a solo practitioner with my own firm. I do some general family law, but I do a significant amount of child-specific work, including guardianships, adoptions, attorney for children, guardian ad litem, and representing children in child protective cases, particularly in Bonner County, which I have done for many, many years. I've done countless hours of additional training in the areas of child development, the impact of domestic abuse and trauma on children, the impacts of addiction, including pornography addiction, on children, etc. I'm a member of the Idaho Women's Lawyers Judicial Commission for the 1st District. I've recently been invited to become a member of the Department of Health and Welfare Citizen Review Panel, which I have accepted. I volunteer at Safe Passage, which is a local women's shelter, to protect and represent women at protection order hearings. I also do pro bono work for a significant number of victims of domestic violence. It is in that capacity as a family law practitioner.
You're out of time. Can you wrap it up?
I sure can. So here's my concern. My concern is that I believe, obviously not in all cases, but you are getting you're getting what can be at times a skewed perception of what has really occurred in cases, and we are unable to defend ourselves. We cannot tell you the specific circumstances in any of the cases. We cannot talk to you about how the outcomes came about because of facts that may be left out or ignored and not shared with you. And I would just like to encourage the committee to make sure that you have a full view, including from practitioners that do this work day in, day out. We could all make more money and get attacked less if we did some other area of the law. But the judges, the guardian ad litems, the child advocates, and the attorneys, by and large and far, and there are many that are here today, do this work because we care about our community, we care about these families, and we care about these children. So you are being given a lot of information, bits and pieces that are being presented to you as being what define the outcomes in particular cases, when we are all sitting here knowing that there is vast amounts of more information that you are not getting that we can never tell you.
We appreciate that. Would you be willing to leave your information?
Absolutely.
That would be super. Is Chris Greenfield here online? Troy Thompson? No, Troy Thompson. Tyree Strong.
Troy Thompson was yes.
Oh, Troy Thompson. Let's do Troy. And on deck, we'll have Adrian Norris here.
Yes.
Okay, so we'll do Troy and Adrian.
Troy doesn't seem to be connecting, so I'll do Adrian.
Okay. Is Abigail's standards here? Logan Summers. Are you still finding them?
Adrian Norris is correct.
Okay. Adrian, when you're ready, go ahead.
Hi, my name is Adrian Norris, and I'm speaking as a private citizen, but many know me as the Boundary County Watchman. I advocate for transparency and accountability. Legal representation often costs thousands, sometimes hundreds of thousands of dollars. And as a result, many Idahoan families are forced to exhaust their life savings to investigate through or to navigate through the court system. This reality undermines the constitutional principle of equal access to justice. Additionally, I've observed what appears to be vexatious litigation, I hope I pronounced that right, where excessive or trivial motions are used to overwhelm or financially cripple the other party. Such tactics go unchecked. Then the result is often a default judgment. Judges rarely intervene, leaving the oppressed party as a severe disadvantage. Also, many are having difficulty obtaining their documents from their attorney. They report being ignored or finally receiving a copy after begging. Perplexing, since under Idaho Rule Code of professional conduct 1.16a, a lawyer must surrender most papers and property to the client that is entitled. I believe justice that is inaccessible is justice denied. Small steps towards education and empowerment can restore hope for those who often feel overwhelmed and defeated. One small change that might help would be to modify Idaho Code 3132 to reflect a more realistic court fee to obtain court documents. Right now it's $1 per photocopy page. I recommend adding a $10 per 8 gigabyte thumb drive. Should redactions be needed the first 2 hours, there should be no charge, similar to Idaho Statute 74. Please note that the files that are already available at the court's public computer are already redacted. Redaction should only apply to mostly sealed files. I have sat at a public computer using my phone to screenshot documents for free. I can capture about 400 pages in 2 to 3 hours, and most year-long cases have at least 500, if not 1,000 pages or more. And boy, that could get expensive at $1 per page. And it is physically restraining on my wrist and back. The image quality is far inferior to the digital download. Some individuals feel uncomfortable sitting at the public computer due to... Okay, I'm almost done. 2 sentences. Due to the embarrassment or other personal reasons, having the option to request a low-cost thumb drive or an email delivery would be appreciated. I've discussed this with the Boundary County Clerk, who indicated she has no objections to my suggested fee adjustments. Thank you for your time.
Thank you very much for your testimony today. We're in the speed round because we're running out of time. So is Kevin Johnson here? Yeah, I think we already did it. I have 3 different lists I'm going from. So how about Alexa Henderson? Is Alexa here? No. Okay, how about Kathy Westbrook? Okay, Kristen Tarr. Robert Erblin. Okay, Linda Hoffman. There we go. And next up will be Frank Ellman.
Okay. Hi, my name is Linda Hoffman, and I live here in Kootenai County. I'm here to testify not only on behalf of myself, but on behalf of the hundreds of women silenced by Idaho's family court system. I was married for 37 years, and I homeschooled 6 children, supported my husband's business, and stayed in the marriage throughout emotional, financial, sexual, and spiritual abuse, believing that the lie that suffering made me godlier. My husband confessed to a life of sexual sin, addiction, and financial deception that he lived throughout the entirety of our marriage. A doctor warned that staying would kill me, so I filed for divorce. And what followed was not justice, it was betrayal at the hands of my judge in Kootenai County. Despite overwhelming evidence of my husband's abuse and repeated court order violations, the judge sided with him at every turn. I was forced to submit 2 years of private text between me and my 6 children, which my husband's attorney twisted to label me as manipulative. The judge discarded the live testimony of the abuse witnessed by or experienced by my son Jordan, and dismissed a panic attack that I actually had during the court break, which required paramedics, as dramatic. He ignored the psychiatrist who confirmed I was mentally and physically unfit for work due to trauma. But perhaps the cruelest blow came in the judge's ruling against me. He allowed my husband to claim business debts and forced me to be responsible for half of them, including a $200,000 loan my husband gave himself and then forgave. He even deducted my husband's unpaid taxes from my half of the marital assets, despite the fact that I never had access to those accounts. I was locked out throughout the separation. My accountant documented that during the separation, my husband spent nearly $1 million, most of it hidden. Just 2 years before the court hearing, our joint taxes were over $800,000, but during the court hearing, his attorney proved that it was negative $150,000. The judge accepted my husband's fabricated numbers, relied on his attorney's narrative, and treated the deception as truth. And my husband forged my signature on that same tax return, a felony. It was entered into evidence, and the judge did nothing. Okay. Since the trial, I've also faced serious danger. I was nearly tracked by someone impersonating law enforcement who knew private details about my location and legal proceedings. A friend of mine shared the story with local sheriff at a public sheriff meeting, and the officer immediately responded with, "Was she recently in judge court?" That question said everything. It confirmed that what happened to me was not isolated. Others are seeing a dangerous pattern, and we are deeply concerned. Please help make this right.
Thank you for your testimony today. Remember, there is a survey that we're having people fill out that's kind of finding trends that we're running into. So I would encourage you to connect with someone on that survey. Frank Elman here. And after Frank, is there Tina Switham? Or Tina, is there Tina here? Okay, Tina. Please introduce yourself.
Yes, good afternoon. My name is Frank Elman, and I'm a resident of Kootenai County. Also, a retired Los Angeles Police Sergeant, 28-year veteran. I'm here today because my daughter suffered a mental health crisis, and my grandchildren were taken into custody of the Department of Health and Welfare in August of 2024 through the filing of a demonstrably false affidavit looked at for by a CPS worker. Despite this, I applied for and became a licensed kinship foster parent for my grandchildren on December 10th, 2024. Since that time, despite repeated assurances by the department that my grandchildren would be transitioned from their current non-relative foster care placement to my home, the department has failed to do so. So I want to talk about some statutes. The Child Protective Act 1629 states at number 11, anytime the department is considering a placement pursuant to this chapter, the department shall make a reasonable effort to place the child in the least restrictive environment to the child, and in doing so shall consider, consistent with the best interests and special needs of the child, placement priority in the following order: A, a fit and willing relative; B, a fit and willing non-relative with a significant relationship with the child; C, foster parents and other persons licensed with a significant relationship with the child; and D, foster parents and other persons licensed. The issue with the language contained in Child Protective Act 1629-11 is that it only requires the department to make a reasonable effort to place the child in the least restrictive environment to the child, and in doing so, consider, consistent with the best interest of special needs of the child, placement priority according to the statute.
You try to wrap it up. Your 2
Sorry.
minutes. No, go ahead.
Well, there's a lot more, but basically, in conclusion, the language of the Child Protective Act must be revised, which would necessarily imply a revision to the Juvenile Rule 43A and B in their current format, neither provide any mechanism of accountability for the department related to their placement decisions, and neither serve the best interests of children in their care.
Feel free to email us your testimony.
Sure.
We'll have that on the record. This has been something that's been brought to our attention before many times, so.
And we're working.
And we have been trying to work on that code, so thank you so much.
Thank you.
Michael or Michelle Carolla?
Yep.
Oh, yes, she's gonna be online. And then Shelby Frazier will be next. Michael there?
Yes, Chair and panel, are you able to hear me?
We can hear you. Try to keep it at 2 minutes. Introduce yourself and thank you for coming today.
Yes, ma'am. Michael Carolla, a retired military veteran, just recently relocated to the area. 13 months into the process, I've not had any access to my children. I'm just going to fire off my suggestions, and if you want the details of my case, I'd be willing to disclose everything involved. But I feel this process needs to somehow involve law enforcement more. The only folks who have been able to help me with anything have been law enforcement. And we need to get solid definitions like alienation and custody interference, because I had requested law enforcement assistance during custody interference, and they were literally going to arrest the petitioner the next morning when a protection order was used against me to intervene. I believe that when a judge orders the joint family law restraining order that states behavior, like Honorable Walsh talked about being measured for, that should be a law. So when someone violates what is going on there, like my situation where the petitioner broke back into our home after establishing a separate domicile. I called law enforcement 4 times, and respectfully so, they're unable to respond due to a civil matter, but I lost every inch of community belongings. I hate to overburden law enforcement, but when we talk about all the money involved in this big machine, those are the ones that seem to be there doing the job for the right reasons, and they're the neutral, biased individuals. I also recommend that these proceedings need to be recorded. 5 out of my 7 temporary motions have not even been entered into the court, and when transcripts were requested, the judge's rulings or even suggestions are not even captured by the clerk. It's 2025. We have to have an ability to get both sides of the story and have it captured in real time to be able to present it to you folks so we can make change based on what actually happened. Supervised visitation is also a challenge. The bias and authority that is leveraged by these individuals, but apparently no one is in charge of them. I'm currently dealing with a situation where my child choked during a visit on debris in the room. Come to find out that they're not even required to have a CPR certification in the state of Idaho, but yet the notes find it concerning that I did not start CPR on my daughter that was alive, breathing, and with a pulse. And now the judge is making rulings on my perceived behavior by a statement of an agent of the court, apparently, that is not even required to be certified as CPR. So I think accountability is our hugest issue. And so therefore, if we want to tamp down on the costs associated, the tons of temporary motions, there needs to be more law enforcement availability to capture these situations, because a temporary motion with a police report can be handled, answered, and decided upon a lot quicker than a bunch of hearsay. And those are some of the challenges.
I appreciate your testimony today. Can you email any of that in if you have it written down? We'd appreciate it and have it on the record. And thank you so much for your time today.
Thank you, and God bless.
Thank you. Shelby Frazier here. Pamela Nichols.
Shelby's online.
Shelby's online. Let's grab Shelby. Kristen Tar. Kristen.
Hi, sorry, can you hear me?
We can hear you. Shelby, when you're ready. 2 minutes, please.
Okay, I think I just want to first start out by addressing a concern that was brought up at the last legislative meeting in Ada County. And I believe the question was raised as why abuse is presented after the divorce or after somebody leaves. And I think it's very important to note that most of the time during abusive marriages, whether that's to the kids, to the spouse, or both, it is a scary place and it's not safe to report when you are in those situations. I think the second part to that is the abuse on the children. Most parents leave because it's no longer safe for their kids to be in that situation. So we leave to protect them. And society tells us to do that. And the law tells us to report the abuse when it's occurring. However, when you are a mother and you report abuse, you are then targeted and you face losing custody when you report abuse. I think that it's also important to notate that when you leave these relationships and the custody gets decided, children then, or the abuser then has free access to those kids to further the abuse that they are occurring. And then it allows those children to come back to their safe parent to report that abuse. And I think we all know that kids, they bond to their safe parent. So when they fall down when they're little and they have boo-boos, they go to their safe parent. When they want to celebrate something exciting, they go to their safe parent. So it stands to believe that when something bad is happening to them, they are going to report to their safe parent. However, when that safe parent then reports the abuse on their behalf, they are targeted and you face losing your child over and over again.
Thank you for your testimony today. We really appreciate it. Okay, Pamela Nichols. Nope. Patsy Grant. No. McQuana Ben Johnson? No. Veronica York?
Yep.
Yes.
Hello, can you?
We can hear you.
Thank you for having me today. I am a nationally recognized domestic violence expert in child custody cases. I've been qualified as an expert in 10 states, and that does include Kootenai County, Idaho. And I want to talk today, just I guess, really briefly about the information that we use in our child custody cases, most specifically the ACE research, adverse childhood experiences, and the Saunders study. These are the two most important studies to have in child custody cases that involve any allegations of domestic violence or child abuse, because the ACE research goes to the essence of the well-being of children who have been exposed to trauma, child abuse, or domestic violence. And what the ACE research tells us is that children who are exposed to these things will live shorter lives and face a lifetime of health and social problems if they are not protected. And so in the context of child custody, we want to make the safety and health and well-being of the child the first priority above the other best interest factors. The Saunders study was a study, and by the way, the ACE research is out of the Centers for Disease Control and Prevention, so it's very highly credible research that's used in all facets of our society, not just family court. The Saunders study, again, highly credible scientific research out of the U.S. Justice Department. It was a study that assessed the domestic violence knowledge of judges, lawyers, and particularly custody evaluators. And fundamentally, what the Saunders study says is that court professionals do not have the specific knowledge and expertise needed to recognize and respond properly to child custody cases that involve domestic violence. These professionals need to have specific knowledge in 4 areas that include how to screen for domestic violence, risk assessment, post-separation abuse, and the impact of domestic violence on children, which is what the ACE research tells us. So without that specific knowledge, court professionals tend to believe the myth that mothers frequently make false reports of abuse, and they rely on unscientific alienation theories. And because of that, they're making recommendations and decisions that are harming children. And so as we move forward, I'm part of Goldstein and York DV Experts LLC, and we do expert witness work across the country. We advocate for what we call.
Wind up a little bit. You've been out of time, but go ahead and finish up.
I'll just end with that we advocate for the Safe Child Act. The Safe Child Act is a comprehensive legislation that we would think would solve the problems that we're having in family court. That would include using proper experts that are domestic violence experts. The Saunders study said we need multidisciplinary approach. It is based on using evidence-based approaches rather than ideological or subjective ones. And it includes training for judges and also an evidentiary hearing prior to any parenting plans being implemented so that we can make sure that we understand the domestic violence piece before moving forward. Thank you.
Thank you for your testimony today. Yes. Okay. Who in the audience has not been called on? Is there anyone out there that Christina Greenfield has been trying to do? Okay, so we have 1, 2, 3, 4. Okay, I have Bill Green. Come on up. And what was your name? Heidi. Heidi, you testified before, so we're going to skip you this time. Come on up, Bill. And what was your name, sir?
William Cathers. Why don't you have him go first, because I'll be slower getting.
Okay, come on up, William. Tell us your name so we can mark you off. Did you sign in? Okay, that's why we don't have you. Go ahead. What was your name?
William Cathers.
Okay, when you're ready. What was your name?
William Cathers.
Okay, got you. put you on the spot.
Sorry, I wasn't there.
You need a minute, you put Bill up there.
Yep.
Bill, jump on up there. You can stick to 2 minutes, that'd be great. We'll try to get everybody in.
Good afternoon,
Thank
Madam
you.
Chair, members of the committee. Thanks very much for coming. I appreciate your service so much, especially on this topic. Just want to say something kind of quick. In my other life, I spent a lot of time in the courts in Whitney County, expert witness for kids in custody evaluation. So I was guardian ad litem and parenting coordinator, board certified in adolescent child psychology, stuff like that. So I was involved in a lot of those things, saw a lot of cases. And the one thing that I noticed that I thought might be a reasonable addition is that at the end of the case, the judge would ask me for a big evaluation, all kinds of reports, or one big report, and lots of data points and specific recommendations, which I would gather by visiting parents, watching parents with their kids, asking them about people know about their parenting, going all around asking other people who knew them what they thought about their parenting. And these cases were like really high conflict, as some of the judges was talking about, and very complicated. And in the end, you make a bunch of recommendations, and I always wonder, and the judge would most times do what you recommended. But then I always wonder, well, what happened afterwards? There was never any follow-up. And sometimes when it would go one way or the other, and so it was always one side is upset, then something would blow up on the side that won, supposedly won. And then it comes back to court, and I say, well, why didn't you follow what was recommended? That would never happen. So there's some one addition you could make, and I brought this up in Boise conferences many times, at least one time, and the response from the judges was, we haven't got time for that. There's so many cases, there's so much going on, that to add another thing would just make it even more difficult. But I think that a lot of things gets lost in the cracks when there isn't a follow-up, because parents are really trying to do their best, and they get involved in these cases, and they've got their child back, and they're trying to work it all out. Something falls through the cracks, and they try to avoid it, and it doesn't get known to the court or to the people who can make a decision, and that gets lost. I think that would be an addition.
Thank you so much for your testimony today. William Cathers, come on up.
I think I'll be able to do that in 2 minutes. So I'm just gonna wing it.
Okay, let's do it.
I started off 3 years ago in a custody situation where I was separated from my daughter, and her mother and I had a verbal custody agreement that seemed to be working fine, and I was working a lot trying to prepare for a down payment on a house. And despite my efforts to have that relationship work out, not everybody's meant to be. And so at age 4, I stopped pursuing that relationship and went to pick up my daughter, and a visit was separated. She had moved out of town and told me that I couldn't see my daughter. And I tried to handle that with grace through the conversation. I realized that was not going to be effective. So I, within 2 weeks, started a legal custody case. An officer showed up at my house and served me with a protection order on behalf of my daughter. And I'll get to the point of what I feel needs to change. The processes that have been put into place for my case, I don't feel I was properly prepared or educated on how to deal with any of those things. I sought out legal counsel for multiple attorneys. They want to charge you for each visitation just to have a consultation. So going through the process, the attorneys didn't want to take on an already established case, and I realized I had chosen the wrong attorney from the start. And the processes that led me to, and I'm just messing this up. I emailed my testimony to you guys. I feel that there are key points. I chose a supervisor that I feel was falsely reporting, and through the effort of trying to replace her, I realized I'm going to lose a bunch of time with my daughter in order to replace her, and I couldn't pull the trigger on that commitment to replace her, and I should have. And in the end, I feel that there was a mandated separation from my daughter, and that caused me to go back into court, and I communicated to the judge, I don't feel that this supervisor is a good fit, and their credentials changed to be a therapeutic supervisor. And they're the only one in this community that has those credentials. The next one was in 8-hour drive commitment. So I'm stuck paying $1,000 for one visit for an hour with this lady, or I take on what I feel is a false reporter to the courts. So I stuck up my pride and I say, okay, I'm gonna have to deal with this situation, but I'm not gonna go at it blind. I'm gonna audio record this session so that when false testament is presented to the courts, I am armed. And so I took the audio recordings to the court and I tried to say, these are the circumstances, and I feel like you're putting a tremendous weight on this person that acts like a judge, and because you, in some regard, are taking the weight of this person, and it's tremendous. So,
gotta wrap it up. Sorry.
Yeah, I know. Sorry. I feel that there has to be a level of justice to the weight of evidence submitted, and that all evidence that should be or that is presented should be weighed out. And when you're talking about perjury of the person that's overseeing visitations, which is the key element of my case, that has a tremendous weight. And for someone to just disregard that and take away full custody of my daughter moving forward, when I feel allegations were made and I went through 2 different stories that I had to fight and prove my innocence on, but the weight of that carried through 3 years of separation of my daughter. She's not been in my home, has not seen any of my family, has not had any contact, and this is an unresolved case, and I don't know how to move forward to when there's no like cards, there's nothing that I can say, well, how do I move forward? How do I show this judge that I'm a good dad and that I deserve my rights that have been falsely taken?
We're gonna have to cut you off, but we're gonna be done in 15 minutes, and let's follow up after this.
Okay.
Thank you. Okay, who's left that didn't get to testify? Okay, have you testified before?
I have in Boise, and then if I don't.
How about anyone online waiting?
Gertie Okay, Kelly O'Toole.
Let's do Kelly O'Toole, because I remember her name. Let's see if she gets on. Kelly, are you there? Kelly, you there? There she is. Kelly, you're on mute. You're on mute. You have 2 minutes and we're going to keep it to that, sorry to say. So tell us the problems that you had in the system. You're still on mute.
It doesn't seem to be working, Kelly.
We're going to come back to you. Can you talk? You're still on mute. Okay. So, one more online. Who is the other one?
Cynthia Redford.
Cynthia? Cynthia, are you there?
They decline.
Okay. Okay, so that's it for the online testimony.
Frankie Revsler.
Frankie, can you come up? Let's do Frankie.
Hello.
Hi, Frankie. You have 2 minutes if you can share your testimony with us.
Yes, ma'am. Okay. Hi, I'm Frankie. I'm 16. I used to live in Idaho. I've seen so much corruption happen in the court system that I'm considering being a judge when I grow up. What I want is I want children to be heard in the court system. They have no voice, especially if they have proven that they have made money and pay taxes. They should be capable of speaking their own voice. My dear friend, she has had the worst couple months of her life because of this court system, has been beaten, police reports, judge said no to all of it. It feels hopeless. And in a system where it feels like you have no hope, not a lot, like the victims of the court system go crazy. Like this poor woman I know, she couldn't speak her right mind because she was so overwhelmed with the injustice of this system. And when judges see that, they think you're just crazy. When you're actually a parent who is sad that you can't see your children. This woman, she hadn't seen her children for months. And when you care so much for someone, you feel emotion. And that is perceived as discreditable in the court system. The system, I feel, was made for criminals to be able to thrive in. Even ironic, isn't it? But I've just seen over and over many criminals have won. So just
Frankie, we appreciate
justice in the court system.
We appreciate your testimony today, and we look forward to your law when you become a judge. Maybe you'll come to the committee. Thank you for your testimony today. Folks, I think that's about it for the testimony. And there's one more in the back, it'll be our last one, and then we'll end a few minutes early, and maybe we can network with anyone that needs to leave their information with someone or connect with some of these online surveys or groups. So come on up and introduce yourself.
If I could I read a penal code, a case law, and then try to squeeze in my 2 minutes? Will that work? Okay, so first one is
Name.
Sorry, Mark Esquivel. Dad Talk Today. I'm a liaison for Dad Talk Today. I'm the founder and director of National Family Justice. So the first penal code is Title 18, Crimes and Punishment, Chapter 45, Kidnapping, under 18-4506. Takes, entices away, keeps, or withholds any minor child from a parent or another parent or institution having custody. That's the first statement. So it's not a civil matter. It's a criminal one. The second one is the Due Process Clause does not permit a state to infringe on the fundamental rights of a parent making child-rearing decisions simply because a state judge believes a better decision could be made. Sandra Day O'Connor, Troxel versus Granville, 2000. Now my 2 minutes. Excuse me. Okay, so Dad Talk Today is providing a comprehensive live stream of the highly anticipated John Mass wrongful death trial. This trial has captivated attention since its inception in February 2021, centering on the tragic events surrounding the death of John Mass, who was fatally shot by his ex-father-in-law, Jim Bashir. The incident took place in the Sowers grocery store parking lot in Lewiston, Idaho on February 5th, 2021, during a mutually agreed upon time for John to see his children, as confirmed by the courts. While he waited for his ex-wife, Rebecca Bashir, to arrive with their children, John saw a car approaching and assumed it was her because it was the car she drove. Tragically, it was Jim Bashir, his ex-father-in-law, who shot John 3 times, once in the back and 3 shots going, once in the chest, 3 shots in the back while he ran away to try and survive this attack, killing him a short time later. Rebecca arrived with the children driving a different vehicle, literally within like 5 minutes. Throughout the preceding 3 years of family court proceedings, John faced baseless allegations of sexual molestation by Rebecca, who he vehemently denied. He underwent extensive evaluations, including lie detector tests and psychosexual assessments, proving without a doubt that the accusations against him were false and that the acknowledgement and that was acknowledged in a court of law. In a previous murder trial, a written statement from an investigator in Wilson, North Dakota, was released to the media, confirming that John had passed every test and demonstrated no propensity for alleged behavior. Despite the evidence, Jim Bashir received only a sentence of voluntary manslaughter following the murder trial. The live streaming event currently going on right now, they're in deliberation, to shed light on the journey of John Mass and the battle he faced firsthand. Again, it's going on currently right now. Let me jump ahead. There are 2 documentaries chronicling John's story titled I Stand With John and his sequel, I Stand With John Wallace in Lewiston. They've been released for free on YouTube. Everyone can go see it. Families deserve justice and the truth to be known. We hope live streaming will provide transparency and support for the Matz family and seek justice and heal.
Thank you so much for your testimony today.
Thank you.
Everyone, thank you for coming out today, taking the time, being here all day. We're going to have more hearings across the state. We're going to be in Idaho Falls next month. Then we're going to be back down in Canyon County and then Ada County. So if you know other people that want to share ways to fix the system or ways we can look into these processes and make sure we understand what's going on and we need to clarify the law, encourage them to get us the information and show up in one of those hearings. And we'll probably end up, we've talked about it, we're probably going to end up doing one last one where we're going to pick up any testimony for people that didn't get to share or people that want to be anonymous. So you're very brave, and thank you guys all for showing up today. And with that, we're going to be adjourned.